gonna take a minute.
So Attorney General Fry has sent in his testimony. Do you want me to forward that to the committee, Soupy?
I didn't see it. If you
It
want
just
to
came
have-
in, just
Oh,
came
okay.
in.
Thank you.
You want me to do that?
That'd be wonderful. I can do it too, you know.
Well, I didn't know that you could do that, but
I have access to my email.
okay.
But when I went to Zoom, I was not getting what I thought I was supposed to get. Okay, I can go email.
Okay, it's not a rush. It's LD 132.
Is it from Mark or is it from the Attorney General?
I believe it's from Mark.
Okay, I'm sending
The
it.
email's from Mark.
I am forwarding it.
That will be our last bill for today.
Right. So Soupy, I do not believe I have the power to move anybody.
You are now a co-host.
Oh.
I need to go in and make Tom. You can make Tom a co-host.
Okay, I can.
Thank you.
Oops, I just let Leo in. No, I didn't. Are you ready to let people who are testifying on the first bill in?
I didn't see anybody on my list for
No,
145.
Just,
No, actually, Leo might not have, but he has testimony for it.
Okay, just sent the Attorney General's.
Okay.
Okay, I'm done. I can't, I'm closing that out.
Okay, I did promote the sponsor for LD 124. Senator Cornett, I don't know if you're aware, but you are the presenter of LD 145. And David Backer is here from the Probate and Trust Law Advisory Commission to present testimony on it.
thank you. I was aware.
Okay.
Good morning, everyone. Just wait a minute for other members of the committee who still might need to join us. We'll get started momentarily. All right. Good morning, everyone. We are convening the public hearings for the Joint Committee on the Judiciary. We have a quorum of committee members here, it looks like, and we typically start our meetings with introductions by the committee members. So we'll have committee member introductions first, and then we'll take up our committee rules, which we need to adopt, which is kind of a housekeeping thing that happens at the beginning of every session. And then we'll move on to hearings on bills. And the order, just so that everyone knows, is that we'll start with LD 145, and then 124, 159, and conclude with 132. And the process will be that as we take up a bill, the sponsor will have the first opportunity to speak to the committee, and then we'll take witnesses, people who want to testify in support of, and then in opposition to, and then finally neither for nor against. The sponsor will have unlimited time to present the bill and answer questions. And then for all of the subsequent folks who testify, you'll have 3 minutes to provide your statement. And then the committee may ask you questions, but we'll ask people to please limit their comments, other than the sponsors, to 3 minutes. And I will be timing on my phone, and I'll hold up the phone when you're about 20 to 30 seconds from the end of that 3-minute time frame. There is a chat function that is part of our electronic meeting. Please do not use it other than for technical issues. It is not part of the substantive record of the hearing. It's, and so we appreciate that. So at this point, we will start with committee introductions, and I'm just going to read through our committee list and ask people to introduce themselves. And I think today we will start with Representative Reckitt.
My name is Lois Reckitt, and I represent District 31, which is the ocean end of South Portland. Thank you.
Next, Representative Moriarty.
Good morning. I'm Steve Moriarty, representative of House District 45, which consists of Cumberland, which celebrates its bicentennial next month, and the southern part of Gray.
Happy birthday, Cumberland.
Thank you.
Representative Hagan is not able to join us quite yet today. Representative Downs.
Yes, good morning. I'm Representative Kathy Downs, and I represent District 130, which is Bucksport and Norrington. Thank you.
Representative Libby.
Hi, thank you, Madam Chair. I'm Laura Libby, and I represent District 64, which is part of Auburn and all of Minot.
Thank you. Representative Poirier.
Thank you, Madam Chair. Jennifer Poirier. I represent House District 107, which is all of Skowhegan and a small part of Madison.
Representative Evangelos. Let's see that he is not here yet today. Representative Newell.
Good morning. Thank you, Madam Chair. I am Marina Newell, Passamaquoddy Tribal Representative.
Thank you. Let's see. Representative Babbage.
Yes, how do you do? My name is Chris Babbage. I represent House District 8, which is part of the town of Kennebunk.
Senator Keim.
Morning, everyone. My name is Lisa Keim, and I proudly represent Senate District 18, which is northern Oxford County, and 2 communities in Androscoggin.
Thank you, Representative and Co-Chair Tom Harnett.
Thank you, Madam Chair. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner. Thank you.
Thanks. And I am Senator Ann Carney. I represent Senate District 29, which is South Portland, Cape Elizabeth, and some of Scarborough. And we have, in addition today here, our wonderful Judiciary Committee Clerk, Susan Panett, and our legislative analyst, Peggy Reinsch. And they are available on the screen. And Would you like to say good morning, or you? All right, thank you.
Good morning.
All right, so the first matter that we'll take up today is the adoption of our committee rules. We've talked about the committee rules a few times, and I believe all committee members received a copy of the rules from our analyst. And you've all had a chance to review them. And at this point, I would entertain a motion. Representative Moriarty?
Madam Chair, I move that we adopt the rules received on February 8, 2021 as the committee rules for the 130th. And this is not part of the motion, but by way of identification, this particular draft shows a few changes colored in both yellow and green, just to the extent that anybody may have mixed this draft up with another draft.
Okay, so we have a motion to adopt the February 8, 2021 version of the committee rules, which includes highlighted changes in yellow and green. Do we have a second?
Yes, I'll second that.
Thank you. So we have a first and second. Is there any discussion? Representative Moriarty?
Thank you, Madam Chair. Just want to ask Senator Kime whether she agrees with that portion of the rule at the top of page 5, highlighted in green, but in parentheses shows the words "and committee analyst." It was my intention in moving this draft that we provide that both the committee clerk and the committee analyst may approach the committee members seated at the committee table. So I intended to include both of those individuals. And I wonder if Senator Kime, as the person who seconded the motion, concurs with that.
Senator Kime?
Thank you. Yes, I do. I believe both, well, when our committee would be Soupy and Peggy or Sam would all be able to approach us.
Good. Thank you.
Thank you. Representative Evangelos, did you have discussion related to the motion to approve the committee rules?
Be sure I'm not muted. I'm not sure, but if it's not germane, we can take it up afterwards. But I'm just not clear on the caucusing process within our committee. I don't know if it falls within the committee rules, or just briefly, I want to take it up after we do this, because I'm an independent and I'm just not clear on what the process is. Of course, when we met in person, I was clear. People would break up and go to the rooms, and sometimes they'd invite me and sometimes they wouldn't. But I want to get clear on that. And if it's not an appropriate time, can we take a minute after we do this to discuss that, so I can get instructed on what the process is?
Yeah, I thank you for bringing that up. I have a suggestion. It's not really within the scope of the committee rules. And so what I would suggest is that perhaps you can talk with committee chairs, Tom and I, after this meeting. And if we're not able to resolve it and you want to present it to the committee as a whole, we can put it on the agenda for our meeting on Tuesday.
Well, I don't think it has to be that elaborate of a discussion. I just want to know, when people request a caucus and go into caucus, what's the process? I don't even know if I have the technology to make it happen. I assume they're able to talk to each other under some venue. And I don't have a cell phone. So that's all. Can we just spend a minute? I don't want to have to meet with you two privately, because I want the other members to be aware of the discussion. So with your permission, after we do the rules, could we just take 2 minutes to do that?
So just for the information of all of the members of the public who are listening and the other committee members, we are still figuring out the process for having caucuses in the electronic meeting format. And I have not had time during the work week to do that. And so I'm going to figure that out over the weekend. And so it would be really constructive to be able to talk with you about it once I have answers to the questions that I anticipate you'll ask. But right now, we don't have that process nailed down. And so I can't really actually provide you with any information, but I could over the weekend after I have some time to look into it. So I would just ask that you give us a little time to figure out the process so that we can answer your question.
Okay, assuming that we're not going to have any caucuses today, if for 20 seconds, could one of the Republicans weigh in and just tell us how they did it the other day? Because I just, being an independent, we're at a little bit of a disadvantage operating electronically. We're being left out of a lot of information that comes from the State House, and I'm just feeling a bit disenfranchised, to be honest with you. I mean, can one of the Republicans just tell me what they did the other day so I at least have that? Thank you.
Well, let's, Senator Keim, do you want to address this now, or can we proceed to a motion on the pending motion? Because this conversation actually is not related to the pending motion.
I'd be happy to vote and then respond to Representative Evangelos.
Great. Thank you very much. Okay, so at this point, we will vote on adoption of the committee rules, and I'll ask our committee clerk to record the vote. Thank you very much, Supi.
Very welcome. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Downs.
Yes.
Representative Downs votes yes. Representative Libby.
Yes.
Representative Libby votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Senator Sanborn. Senator Sanborn is absent. Representative Hagan. Representative Hagan is absent. 12 members voted yes, Madam Chair.
Thank you very much. All right, that's great. We have adopted our committee rules for the 130th. And now I'll recognize Senator Keim, and then after you answer the question, I would ask Representative Evangelos if you can introduce yourself, because I think you missed our round of introductions. Thank you.
Thank you, Madam Chair. Representative Evangelos, I appreciate your bringing this up in a public forum, because I think, as you stated, if we were in the State House, anyone who is there would recognize committee members leaving and going to a certain location to caucus. As Chair Carney mentioned, we don't actually have a good system right now. We did a phone call the other day, which was just, just a conference call, and we need to figure out a system that works well, because that is clunky getting people on and off. So right now, yeah, we're still trying to figure it out. We don't have a good method.
Okay, thank you very much.
Thank you, Senator Keim. Representative Evangelos, would you like to introduce yourself?
Yes, Representative Jeffrey Evangelos, Friendship House District 91. And Madam Chair, I just wanted to kindly remind Supi or whoever that we get so many emails a day that it would be really important that we receive a link to join the meeting. like 10 minutes before the meeting because I couldn't find my link again. You know, it's why I was late. I wasn't late, but I'm late because I can't find the Zoom link. So if it's right in our inbox when we get here, you know, we get in right away. Thank you.
Yeah, and just Representative Angelos, I believe you have my cell phone number. If not, I'll email it to you and you can always call me at the last minute if you're having a hard time finding the link. I had a hard time today as well, and I will just make sure that I pick up your call if there's a concern about that. Thanks for bringing it up. All right, let's move on to our first hearing today. The hearing is on LD 145, and the sponsor is Representative Tom Harnett, who is here today and will present the bill. You have the floor, Representative Harnett.
Thank you, Madam Chair. Good morning, Senator Carney and fellow members of the Judiciary Committee. My name is Tom Harnett, and I represent House District 83, which is the town of Farmingdale and the city of Gardner. This morning, I'm here to introduce LD 145, an act to amend the Maine Uniform Probate Code. I introduced this bill on behalf of the Probate and Trust Law Advisory Commission and thank the commission members for their tireless volunteer efforts to provide Maine citizens with a workable, fair, and efficient probate code. LD 145 addresses the reality that the Maine Uniform Probate Code, which took effect on September 1st, 2019, had 4 new confidentiality of records provisions applicable to adult guardianships and 5 conservatorships that were delayed until January 1st, 2021 to allow the development and adoption of 6 rules governing those records by the Supreme Judicial Court. Those rules regarding confidentiality of the probate court records have not yet been adopted. Today, you will hear from David Backer of the Advisory Commission about this proposal. And with the chair's indulgence, I know that I have an unlimited time to speak, but I have a limited amount of knowledge on the subject. And I would ask the chair to waive the 3-minute rule for Mr. Backer in the event he needs more time to explain the workings of this bill. He will also explain why it needs to be enacted as emergency legislation to ensure the continuing application and operation of the probate code. Again, while I welcome your questions, I can assure you that Mr. Backer is far more capable than I of answering them. So I thank you for your attention today and would be happy to answer any questions that you might have. Thank you.
Thank you, Representative Harnett. Do any members of the committee have any questions for Representative Harnett? Not seeing any questions at this point, so I will recognize our next speaker, which is Attorney David Backer from, and Mr. Backer, you may proceed.
Thank you, Senator Carney, and thank you, Representative Harnett and members of the committee for the opportunity to speak to LD 145. So I am here in my capacity as chair of the Maine Probate and Trust Law Advisory Commission. And Representative Harnett, thank you for that very nice background on this. As a little deeper background, as many of you may know, the Maine Probate Code that was formerly housed in Title 18A was adopted in 1979 with a 1981 effective date. It had been tweaked over the subsequent 30 years, but it had never been really overhauled in a major sense. The Probate and Trust Law Advisory Commission several years ago took up a review of Title 18A to match it to the much overhauled Uniform Probate Code as released by the Uniform Law Commissioners. We spent 6, maybe even 7 years on that project. It was finally adopted with an effective date of September 1, 2019. The Uniform Probate Code as released by the Uniform Law Commission with comments was an 802-page document. So it's not surprising that after enactment, we are finding little things that need to be tweaked. And these are all little things. The good news is that the new probate code, as it resides in Title 18C, is actually working quite well. Despite the hundreds of provisions, there have really only been a handful of things that have come up for either correction or revising in some way, and that's what's before us today. It's really a fairly short laundry list of things. They're all somewhat arcane. None of them are going to be the topic of a bestseller or box office hit, but I will walk you through them, and I won't take any more time than necessary to give you a quick overview. So the first provision that I'd like to address is a proposed amendment to section 3-1081D. And as to orient us to what this is all about, under Title 18A, until Title 18C became effective, 3 years after a person's death, there was no opportunity to have a personal representative appointed for that person or to file their will with the probate court. And they were deemed at that point to have died intestate without a will. There were a couple very narrow exceptions to that rule. Title 18C it created some additional exceptions. And the paragraph that we're addressing now is one of those exceptions, this section 108(1)D. And what we are proposing is that this paragraph should be applicable regardless of the date of death of the decedent, whether the decedent died before the effective date of Title 18C, on the effective date, or after the effective date. And what the amendment will do is ensure that more than 3 years after a person's death, it will be possible to either have a personal representative appointed for someone who died intestate, or to file their will with the probate court, but for fairly limited purposes. It's for the limited purpose of having a personal representative confirm the title of whatever property there was in the estate for the benefit of the successors in interest. And typically this involves real estate. When somebody dies and there has been no probate proceeding and there has been no personal representative's deed signed, that's the most frequent time when there's a need several years later to clarify title, go to the probate court, ask that a personal representative be appointed, for the purpose of executing a deed. But that is really the sole purpose of the amendment that we have here. The next item, and I'm happy to answer questions on these items as we go, or just go through them all and then take questions to the extent you have any.
I think that's a really good suggestion because it seems like each change is sort of a discrete thing. So let's take questions now on that first described change. And thank you for making that suggestion. Do any members of the committee have questions on the proposed amendment, which is section 1 of the bill that Mr. Backer just described to us? And again, please use your raise hand function unless it's not working, in which case you can raise your real hand. Okay, I'm actually not seeing any questions, so you can move on to the next amendment. Thanks.
So the next one addresses.
I'm sorry to interrupt you, but I do see one question. Representative Libby, did you want to ask a question?
Yes, thank you, Madam Chair. Apologies, I'm wrapping my head around this. And so can you please explain to me, is this fairly common that a will would not be probated before the 3 years? How frequently does this come up? If you could speak to that, that would be very helpful.
Well, it's not terribly common, but it does happen. I mean, I suppose that, you know, over the course of my years of practice, I've addressed it maybe a half dozen times. But if you talk with lawyers who practice in this field, you'll find that, you know, most have had it come up at least once. And if you talk with the probate judges, I mean, they will tell you that, you know, it's certainly not a frequent occurrence, but it does happen. I mean, sometimes, despite the fact that a will exists, people just don't realize that something needs to be done.
Thank you.
Any other questions regarding section 1 of the bill? Or you may proceed, Mr. Backer.
Thank you, Senator Carney. So the next item addresses the provisions that Representative Harnett was describing to you. And those are the confidentiality provisions of Article 5 of the new probate code in Title 18C. And there are 3 identical provisions spread through 3 different parts of Article 5. There is a provision in Part 3, which governs guardianships. There's a provision in Part 4 that governs conservatorships. And there is a provision in Part 5 that governs other protective arrangements. Now, the bill that you have in front of you, which was based on Pat Lack's submission to the Judiciary Committee, only addresses the provisions in Parts 3 and 4. It does not address the provision in Part 5. That was an oversight on our part when we submitted our original submission to the Judiciary Committee. I did submit last week an addendum to that to add the provision in Part 5, which is section 5-511, paragraph 4. And the 3 provisions in Part 3, Part 4, and Part 5 are identical. And they all have a section that says this section takes effect on January 1, 2021. So keep in mind that all of Title 18C had an effective date of September 1, 2019, except these 3 provisions that had a delayed effective date to January 1 of 2021, which of course is already with us. So these provisions are now effective. What we are asking is that the effective date be pushed back further. And in this case, we ask that they be pushed back to January 1 of 2023. The reason for the delayed effective date initially to January 1 of 2021 was to permit the Maine Supreme Judicial Court to address uniform confidentiality provisions that would govern electronic filing in all of the courts. And as you all know, the probate courts are not part of the state court system, which is likely to be a discussion for another day. The Maine Supreme Judicial Court did embark on a really extensive conversation with the public about confidentiality rules. And they did just this last August, in August of 2020, adopt rules that governed confidentiality of records within the Maine Supreme Judicial Court, within the Superior Court and the District Court, but they didn't address the probate court. The Supreme Judicial Court has now turned its attention to the probate court rules, and PATLAC, along with the Maine Supreme Court's Probate Rules Committee, is deep in that process. And a first draft has been created and is, if it's not in the hands of the Supreme Judicial Court now, it will be within a matter of the next couple of weeks. And the justices will take it up and undoubtedly set it for public hearing and comment. And I would expect that they will have rules for us well before January 1 of 2023. So the 2023 date is really probably has lots of extra time in it. We just want to make sure that these provisions really don't take effect. With them having become effective as of January 1, there's been some unintentional chaos created. You all probably know that the Maine probate court records are publicly available on mainprobate.net. The registers of probate have taken the position that proceedings concerning guardianships and conservatorships and other protective proceedings as of January 1 shouldn't be available at all on mainprobate.net. So those are shut off for any of those matters. And it's really created some unintentional hardships for access to basic records concerning those proceedings. So we'd like that to be sort of turned back on. So the request here is that this be done as soon as possible, at least as to these provisions, and that it be made retroactive to January 1, so that the registers of probate will feel confident that they can turn the records back on. Before Title 18C, when we had Title 18A, there were no confidentiality provisions at all in Title 18A that affected access. And that's really what we want to go back to until the Supreme Court tells us what those rules should be. So that may be a little long-winded in the explanation of sort of how we got to this point. But it just took longer than we expected to get rules governing confidentiality from the Supreme Judicial Court, through no fault of the courts. It's just been a complicated process with lots of considerations.
Let's take a little pause here for questions. And I have one that immediately sprung to mind when you updated us on the status of the rulemaking. Do you think that 2023 is still the right time frame, or do you think that the sections could take effect January 1, 2022?
Well, our intent is that they will never take effect because the Supreme Judicial Court will provide us with a comprehensive set of rules that will then permit us to come back to you and change these three sections to reference the rules adopted by the Maine Supreme Judicial Court. So the provisions as drafted, we fully expect and want to never come into play.
Okay, I missed that part of your presentation. That actually is very helpful.
I don't think you missed anything. I don't think I said that.
Thank you. Okay, so I see now why the 2023 date makes sense, and I appreciate that clarification. I'm going to ask other committee members if they have questions, and I see that Representative Libby does. Go ahead, Representative Libby.
Thank you, Madam Chair. I have a kind of a series of questions. Can I go ahead and ask them all and then have Mr. Backer answer whatever part of the series he has answers to?
Yes, go ahead.
They're all tied together. Mr. Backer, I'm sorry, some of these questions might be, other folks might already know the answers to these, but so this is information that was previously only in hard copy, but now with the change to online, they are available online prior to January 1st, when it was all removed due to confidentiality. Is that correct?
Yes. I mean, I'm not quite sure, Representative Libby, exactly when mainprobate.net, went live. I mean, several years ago, well before Title 18C. So until we had mainprobate.net, a person had to actually physically walk into the probate court and ask to see a file.
Okay.
And there have always been certain things in the file that have been considered confidential, just like there is in any probate proceeding.
So the confidential information, so I'm just curious what exactly there's in this type of, in a guardianship, there's often some pretty sensitive information, whether it's medical conditions or whatnot. And I am just wondering who can access that information and what sorts of sensitive information might they be able to access? Is this something that the public has access to? Whereas they would have a lot more difficulty accessing it back when it was in paper form. They'd have to go there and really be intentional with it. I just wonder about how much access the public might have to this sensitive information.
It's actually fairly limited. I mean, some of the information that might be considered sensitive, including some of the medical information, is not available, was not available. But now, I mean, even the fact that a guardianship proceeding has been commenced isn't available. There's nothing available now. The information even regarding the fact that a petition for conservatorship or guardianship has been filed.
I'm sorry, Madam Chair, may I clarify real quick?
Yes.
What I'm asking about is what information was available prior to January 1st, 2021, and what if this passes, what that would allow to become public once more until 2023, and what sort of potentially sensitive information that would be included, and how much public access there is versus those who need the information in order to make the case move forward.
Representative Libby, I'm not sure I can be specific enough in answering that for you. What I'd like to be able to do is get back to you with the specifics on that when you hold the work session on this, to be able to give you sort of a specific list of what was available and would again be available when if somebody was to walk into the court and ask, or if somebody was to go to mainprobate.net to look. Because there are some things that have never been available and would not be available even if we sort of relaunched those cases on mainprobate.net. But I don't want to, don't want to give bad information as to what that was.
Thank
and-
you. I appreciate that being available for the work session, and thank
Yeah,
you,
and-
Madam Chair.
It will be an easy thing for us to provide you with that specific list of what the registers do not make available under any circumstance.
That would be really helpful for the work session. Thank you.
Okay.
Thank you.
Are there any other questions on that section of the bill that deals with the amendment to the time frame? Not seeing any committee members with hands raised. So, Mr. Backer, can you take us through the next section of this bill, please?
Yes, of course. Thank you. The next one is a request to remove the obligation that a conservator provide the court with a protected person's credit report each time the conservator files its annual accounting with the court. This was a new provision in Title 18C. This is not something that existed under Title 18A. And the new provision requires that an annual credit report be provided to the court when the conservator provides its annual accounting. That sounded good in concept, but in practice, what lawyers have found is that sometimes it's just impossible to get a credit report. The credit reporting agencies will not provide one to the conservator. So our request, and as a result, the filing of annual accountings is being delayed because the conservator doesn't have the annual report to be able to provide, the annual credit report to be able to provide to the court. The conservator is required to provide financial statements, bank accounts, investment account statements, all financial information about the person who is subject to the protective proceeding and the conservatorship. But we're merely asking that instead of the credit report being mandatory in all cases, that it be something that the court can order if the court deems it appropriate to do so, but short of a court order specifically obligating the conservator to file a credit report, that the credit report be removed from the list of information that needs to be provided each year in the conservator's annual accounting.
Thank you.
And that's really it. I mean, if a credit report was easier to obtain, it wouldn't be a problem, but it's sort of out of the hands of the conservator sometimes in being able to obtain that.
Okay, let's take a break here and see if any members of the committee have questions for Mr. Backer on this proposed amendment. That was pretty straightforward and a great explanation, and I don't see any questions. Thank you. So do you want to address the next section, please?
Yes, of course. So the next one is also an amendment to the conservatorship proceedings. And this is, we think that we stumbled upon an error in the statute as disseminated by the Uniform Law Commission. Again, this is pretty simple, but the paragraph in question here says that before a court issues an order to terminate a conservatorship, the court has to follow certain procedures to safeguard the rights of the individual subject to the conservatorship. What appears clear to have been left out of this is that those rights of the person under conservatorship should be protected not only if the conservatorship is being terminated, but also if the conservatorship is being modified. And what is left out of this provision is a reference to a modification of the conservatorship. There is a counterpart identical provision in the adult guardianship provision that references terminating or modifying a guardianship. And if we go back and look at the uniform comments to the conservatorship statute, with the comments as published by the Uniform Law Commission, the comments reference terminating or modifying the conservatorship. But the words "or modifying" are not in the statute. And it seems clear that they should have been, and they're supposed to be. And we have notified the Uniform Law Commission of this oversight. And that is really all it is. It's an oversight in leaving out a reference to modification. And this adds an additional layer of protection for the person under conservatorship.
Thank you. Let's take a pause there and ask if any members of the committee have any questions about that amendment to the statute. Not seeing any questions, and that was a clear explanation. Thank you. Do you want to, could you please move on to the next section of the bill?
Yes, of course. And this is the last one. Under the main probate code, there are what are called wrongful death provisions that deal with the distribution of any recovery brought by the estate or the personal representative on behalf of the estate to recover damages for the wrongful death of the decedent. If the decedent died in an accident or as a result of the fault or actions of another person. And under the probate code, and this has been the case for years, the recovery in a wrongful death proceeding is distributed to the heirs of the decedent. In other words, the proceeds are not distributed to the estate to be distributed pursuant to the terms, for example, of the decedent's will. They go to the heirs at law as if the decedent had died intestate. You may be scratching your heads to ask why that's the case. I don't have an answer for that, but that has been the law for years. And we're not asking that that be changed. It's just sort of understood in Maine that proceeds from a wrongful death will go to the heirs at law. What is unclear with the adoption of Title 18C is whether for a death that occurred before the adoption of Title 18C, the proceeds from that wrongful death recovery should be distributed pursuant to the intestate provisions of Title 18A, or whether they should be distributed pursuant to the provisions of Title 18C. And there are cases where it will make a big difference. The intestacy distribution provisions in many cases are actually quite different between Title 18A and 18C. So our amendment here is a request to make it clear in the effective date provisions of Title 18C, which are actually in Chapter 8 of Title 18C, to make it clear that the wrongful death provisions of the probate code and the distribution of those proceeds will be governed by the date of death of the decedent. In other words, the filing date of a wrongful death action won't control it. It's if the decedent died before September 1, then Title 18 will control. If it was on or after September 1 of 2019, Title 18C will apply. It's just to draw a bright line as to which of the intestacy statutes will apply. And that's it.
Great. Thanks. Does any member of the committee have a question about that amendment to Title 18C? Not seeing any questions, and thank you for your clear explanation of all of these amendments today. I would just open it up one final time to see if there are any members of the committee who have a question regarding this legislation that they would like to ask Mr. Backer before we move on to our next person testifying on this bill.
And I will, if I may, just one final comment, and this goes back to Representative Libby's comment or question earlier as to sort of how often does it happen that somebody overlooks the filing of a will within 3 years? I mean, if Representative Libby, if you were to ask a similar question, how often does this issue come up on the wrongful death as to which date will apply? It's going to be 1 in 100 blue moons. This will be a rare issue to have to come into play, but it has come into play, and it will come into play again, in the next few years. And we just want to make it clear when it does come up, which rule will apply.
Thank you very much. So I am not seeing any raised hands among the committee members, and just want to express thanks for your clear explanation this morning, Mr. Backer. And we'll look forward to seeing you at the work session on this bill.
And I will have the information that Representative Libby is looking for.
Great, thank you. And you also suggested a couple of amendments, and we will take those up as well at the work session.
Thank you.
Thank you. At this point, according to our list of people who signed up in advance to testify today, we don't have anyone else for LD 145, but I will just ask if there is anybody who is participating in the electronic meeting who is here to testify on LD 145. Could you please use the raise hand function? And I'm not seeing anybody, so this concludes the hearing on LD 145. Thank you very much. And now we will move on to our next bill, which is LD 124. And I see that we have the sponsor, Senator Searway, here today. And just as a reminder, the chat function is not part of the electronic hearing, so please don't use it for substantive comments. And Representative Searway can present his bill with unlimited time for presentation, although it's a pretty short concept. And we'll ask you questions, and then we'll turn to those appearing in favor of the bill, in opposition to the bill, and then neither for nor against. And those will all be within the 3-minute testimony limit. So Mr. Senator Searway, you may proceed.
Thank you, Madam Chair. Good morning. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. I am Senator Scott Searway, and I represent Senate District 16, which includes Albion, Benton, Clinton, Fairfield, Unity Township, Waterville, and Winslow. I am before you today to present LD 124, an act to clarify the law concerning the priority of appointment of personal representatives under the Maine Uniform Probate Code. Last spring, I was contacted by a constituent whose father had recently passed away, and the individual's the individual was one of 4 adult children, and their father was predeceased by his wife, their mother. And while after the mother passed away, the father met a lady who not too long after moved in with him. The children had never met the lady, and she only lived with him for a few days before he passed away in his sleep. This lady quickly became the executor of all the father's possessions, as the father did not have a will in place, and she was living with him at the time of his passing. The adult children ended up having to pay her off at a cost of $10,000 in order to get control of their father's and mother's estate back. If it had been contested, the amount could have been much higher. Had LD 124 been in place at the time, it would have prevented all of this from happening the way it did, and would have saved this family a lot of additional stress, heartache during an already tragic time. The legislation before you would give priority to the heirs of a descendant over a domestic partner when there is no will in place. However, if the committee feels that a domestic partner should be included in this, you could amend it so that it would give priority to an heir unless there is a registered domestic partner. I reached out to an attorney, Tracy Nail, who deals with the elderly, a constituent in my district, who suggested that these changes to the law, when asked how we could prevent circumstances such as this one I mentioned from happening again. I thank you for your consideration, and I am happy to try and answer any questions you may have.
Thank you, Senator Searway. I open it up now to members of the committee to ask questions, and I see that there are several questions. I believe that Representative Harnett was first, and then Reckitt, and then Moriarty. So recognize Representative Harnett at this point. Representative Harnett, I think you're, there you go, thanks. But it's still, let me see if can you, there's some
Sorry,
malfunction. Oh, there we go.
I'm switching screens, not adeptly. Thank you very much, Madam Chair, and thank you, Senator Searway. I have a question. The term domestic partner is already defined in Title 18C, and it reads, domestic partner means one of 2 unmarried adults who are domiciled together under long-term arrangements that evidence a commitment to remain responsible indefinitely for each other's welfare. And I'm curious as to why you think that doesn't provide the comfort that you're looking for. It would appear to me that a 3-day relationship would not meet that definition. So I'm curious as to why you're moving all domestic partners down the ladder in terms of eligibility to be an executor, et cetera, on a situation that I don't think even met the I think the definition, had it been applied, would have had the same result that you're looking for.
Yeah, well, according to the individual I had talked to, he had stated that it could have been a long relationship, but the problem is, and the attorney had told him that it probably should have been, they should have registered domestic partner instead of just domestic partner. And that was a thought. And So I reached out to Tracy Nail about it, and she didn't think that that she thought the first would be better to put the heirs before the domestic partner, but and then maybe you could have registered partner as a change where it could be before the heirs. But it was just where there's no will, and many times in these situations, there's no real definite time frame of a relationship, long period relationship. They could have just moved in, but they could have had a lengthy relationship. So I don't know. And these people didn't even know this girl. So it's kind of hard on a family when you have somebody just move in and they didn't realize that this lady could take over the whole estate.
May I ask a follow-up question, Madam Chair?
Yes, go ahead.
Thank you. So would you be amenable, if this was the direction in which the committee wanted to go, to keep the order as is, but amend the statute if a domestic partner need to be a registered domestic partnership?
Yes, yeah, sure. I think that, well, I'm just trying to help alleviate the kind of confusion there.
Thank you. Thank you, Madam Chair, and thank you, Senator Searway.
Thank you. I believe that Representative Breckett had her hand up next. Did you still have a question?
No, my hand's down now.
Okay, thank you. The next was Representative Moriarty. And I would just note, Mr. Backer, that at this point, only committee members are able to ask questions, and we'll open it up for public members to contribute in a little bit. Representative Moriarty, go ahead.
Thank you, Madam Chair. Senator Searway, just so that I'm clear, the change you're suggesting this morning would delete the reference to domestic partners and substitute a reference to registered domestic partners, but they would still be at the lower rung of the ladder, beneath the heirs. Is that correct?
Well, that's my proposal, but it doesn't, that can be any way the committee feels would be, if you feel into that can be just changed by registered and leave it as is, that would be fine too, I think. Just that I know, I think either way, it probably will help. But I just kind of felt that Attorney Nail thought that the first was probably the better, but she said that it could be changed either way. So it was two options, basically.
Okay, and do your constituents understand that the personal representative doesn't inherit the estate? He or she simply manages it?
Yes, but certainly, the family felt that they had been, with the father for years, and for this lady just to, pop up and then be in charge of the whole estate was very heartbreaking for them and very stressful. So they were very fortunate that they talked her into just for $10,000, but if she wanted to fight it, she could have, and it could have been very expensive.
Well, I'll just close with a comment that I agree with Representative Harnett in that this person would frankly not have qualified even as a basic domestic partner under the law. She had no claim to be the PR, the personal representative, and certainly had no claim to the assets of the estate either. So my guess is that your constituents may not have sought legal counsel at the time, and they have simply made an assumption that somehow she had a claim to the estate and negotiated a buyout. But it doesn't seem to me that even that was necessary. It's just a personal observation. So thanks for clarifying.
Thank you, Representative Moriarty. And Representative Libby, I recognize you.
Thank you, Madam Chair, and thank you for being here today, Senator Seaway. Just a quick question. What constitutes a registered domestic partner in this scenario versus not registered?
Well, basically, I think that would be just a formality to go register at the courts that you are a registered domestic partner. And I think that could be easily done, just like as almost like any, like a marriage or any type of situation like that. You can just simply go to the court and get it verified.
Thank you.
Representative Babbage?
Thank you, Madam Chair. Welcome, Representative Seaway. Good to see you. In all of these kinds of deliberations, you want to try to be fair to all. I have to ask a very elementary question here. I'm not in this particular situation that you bring to us. I'm not aware of, if there had been an economic relationship established, but I'm actually asking about what is current about how an executor is determined, and how did this person become the executor of the estate? Were there criteria to make that happen? Can you tell me about that?
Well, according to the probate, they felt, I don't know if because of the lady had said that they've had a long relationship, and that she just, she moved in. She's a domestic partner, but she's had a long relationship. And I believe that's, hard to, she'd probably have to prove it if she went to court on it, but the probate went along with it and made her the executrix of the estate. And so this was where they did get an attorney, and the attorney actually came up with the settlement of, the amount, just to an agreement with her to, get her off from that, because it just, the family just felt that she had no idea of what, they have lived, and there was, and they didn't even know her. I mean, so it was very difficult for them.
Madam Chair, just to clarify on Representative Moriarty's question, Representative Seaway, you did testify in your original comments, I believe, that you wanted the domestic partner to be lower on the list. But if there were to be a category in which domestic partner would be above the family, it would be a registered domestic partner. I think I heard that in your comments originally. Is that correct?
Yes, it can, I could go, either way. I mean, if you want to amend it to that, then I'd be fine with that.
Just a clarification. Thank you.
Thank you, Representative Babbage. I see that Representative Moriarty raised his hand first and then Senator Keim. So Representative Moriarty, go ahead.
Thank you, Madam Chair. I just wanted to comment in response to Representative Babbage's question. In the material we have from Mr. Delicata from Legal Services for the Elderly, it's pointed out that on the list of priority for personal representatives, a domestic partner is one step above the heirs, which is just, in most cases, the children. And that's evidently what gave rise to the problem in the underlying situation.
Thank
That's
you,
all.
Representative Moriarty. Senator Keim?
Thank you. Welcome, Senator Searway. Just to ask you, just to restate what I believe the issue is and make sure I'm clear. It's that it's not, what you're saying is not that the family assumed this person would win an illegal battle, but because they felt the language was unclear, that it was the less expensive and easier route for them was to simply pay off this person who was living with their father rather than fight it in court. Is that correct? Is that what you're saying?
Well, she became the executrix, and that's what was concerning to them, where you know, they felt that they knew their father and mother's their estate and everything, whereas this lady just moved in for a few days, and it was concerning to them because she had no, you know, ownership basically in their lives from their standpoint. And so for the probate to say that she was going to be the executrix and there was no will, it was very concerning to them and heartbreaking to them and stressful. And this may alleviate that issue. And I've just tried to come up with a way to do that. And I think this is just my recommendations. I think that it would probably be those two options of maybe and I'm sure, you know, Attorney Becker probably could put some input in it, but I do think that you know, it seems like there's just a little piece missing, and that we really have to do to correct that situation.
Thank you.
Representative Reckett?
Yes, I'm sitting here as what I'm guesstimating as the only former registered domestic partner in this committee. And I'm thinking about the rationale that caused that to happen. And I'm looking at the statute, which gives registered domestic partners already the same category place as a spouse. And I think that it was part of the reason that we registered, having already been together 6 or 7 years at the time, was because there was no other alternative. So my question is, why is there a need to add registered domestic partner, the word registered in domestic partners? It's already in the statute under the spouse part, which is 201-54. So I think that's already taken care of. The only question is, what happens to somebody who is an unmarried couple, whether it's heterosexual or otherwise, are in the same spot? And it has to be that you have to really look at this definition and say, what is a long-term arrangement? And to me, 4 days is not that. So my question is, Senator Searway, is it not already covered that it's a registered domestic partner would have the same spot that a spouse would be in the probate tally? Anyway, that's my question.
Thank you for that question. I think it doesn't say registered in that area. It just says domestic partner, and it says I believe it's the long-term relationship, but it doesn't really say that they had to be living together for a long term. And I believe that there's no specific time frame mentioned, And I think that this would just alleviate by saying registered partner in there to, if you wanted to put that, or put the heirs just above the domestic partner, either way. And I think that would be up to, the committee here to decide on that. I just put this as a suggestion to alleviate the conflict, of families going through this.
Thank you.
Senator Searway, I have one question for you, and I appreciate your concern for the family of the decedent. I'm just wondering, is this the only instance you know of where this has been a problem?
This was just brought to me from that family, and so I really didn't look into more situations. I just know that the attorney had advised them that it would be simple just to put registered, and it would have taken care of the problem. And now that's why I reached out to Attorney Nail. I know they deal with a lot of these issues, and they said that they would recommend changing the paragraph below with heirs and put them above the domestic partner in a situation like this, and then said if you wanted to, you could go to option B and just put registered partner, and that would probably, as well as domestic partners, would probably take care of it as well. So I think that people with more experience than I do in this situation would probably know better which way to go on that.
Okay, well, I think we'll have others testify. Yeah, I just wanted to observe that my concern, I guess, would be that we're fixing a situation that one family dealt with in the past, and the change of switching the priority for personal representative will have a pretty significant impact on a lot of people. And so I just think we should kind of keep that in mind as we continue on this bill. I see that Representative Babbage has another question, and then I'll just check in with committee members and see if we have any other questions for you, Senator Searway. So Representative Babbage, go ahead.
Yes, I think family matters are difficult, and I think this is certainly a worthy discussion, and I think we should change things very carefully when we make any changes. And you want to be fair to the heirs. You want to be fair to a domestic partner, and wonder what might have been the wishes of the deceased. But my question in regard to the case that you bring to us is, did the probate judge make a determination that this was a long-term relationship, and that, what was the other phrase that we talked about in the definition, that there was an indefinite relationship and looking out for the other's welfare? I mean, was that determination made in order for her to be an executor or executrix, as you mentioned? So I'm interested in if that process is being used, and that determination was made in this case to the chagrin of the heirs of the family.
This morning I talked to that constituent, and he says yes, they made a determination. They assigned her as the executrix.
Thank you. Do any other committee members have questions, or shall we move on to others who would like to speak in favor of this measure? Okay, I'm not seeing any hands. Thank you very much, Senator Searway, for being here today and for answering all of our questions. I will now ask if there are any persons present in the electronic meeting who would like to testify in support of this measure? That is, anybody here to testify in support of LD 124? And I see that Mr. Backer, you would like to testify in support of this bill? Okay, so why don't you put your hand down for just a moment, because we have to go in sequence. All right, so anyone in support, final call, and I'm not seeing anybody. And so at this point, we have a number of people who have signed up to testify in opposition. We'll do those, and then we'll move to neither for nor against. And so I'm actually going to follow my list that was pre-printed here and start with Alicia Melnick from Equality Maine. Are you present in the meeting, Alicia? And would you, okay, can you go ahead and proceed? You've got 3 minutes, and then we'll let committee members ask questions. Thanks.
Certainly. Can you hear me? Yes. We're still morning. Good morning, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Alicia Melnick, and I am here on behalf of Equality Maine, our statewide LGBTQ civil rights organization. Equality Maine opposes LD 124, an act to clarify the law concerning the priority of appointment of personal representatives under the Maine Uniform Probate Code because of the negative impact it would have on Mainers in domestic partnerships. As you've heard, domestic partnerships have been recognized in Maine law since 2004 and defines domestic partner as one of two unmarried adults who are domiciled together under long-term arrangements that evidence a commitment to remain responsible indefinitely for each other's welfare. Current Maine law lays out the priority order for determining who becomes the personal representative of the deceased in probate proceedings. The bill before you proposes to move other heirs above a surviving domestic partner in the priority order. This is not acceptable because it would prioritize non-chosen family over chosen family. Adults may make the choice to marry and share their life, home, and finances with one other person, so it makes sense to respect their choice by prioritizing a surviving spouse. Adults may also make a choice to share a home and finances and care for each other without getting married. That choice is equally valid, so it makes sense to respect their choice by prioritizing a surviving domestic partner. And of course, it makes sense to recognize other heirs, such as parents and siblings, in the priority order, but after those chosen spouses or domestic partners. The priority order in current law is particularly important for LGBTQ people who are often estranged from their families due to a lack of acceptance of their sexual orientation or gender identity. If this bill were to become law, many LGBTQ people would be horrified to know that a rejecting or distant parent or sibling could be named as their personal representative in probate proceedings above their domestic partner. But LGBTQ people are not alone in this. There are a number of non-marital families who should not have a family member foisted into the role of personal representative rather than their surviving partner. Finally, we will point out that the same concept came up in the 128th Maine legislature when a bill was introduced to alter the priority order for determining who can act as a surrogate for an incapacitated adult, including the decision to withhold or withdraw life-sustaining treatment. That bill, like this one, proposed moving domestic partners down the priority list beneath parents and siblings. The majority of this committee and a majority of the legislature at that time rejected that bill. We ask you to do the same here by voting ought not to pass on LD 124. And I will just add that the discussion so far has been great. And I would agree that the example presented by Senator Searway could have been resolved appropriately under existing law. And I know the question is often asked if there's a problem that needs to be fixed and unintended consequences of fixing a problem. The fact that you've only been presented with one example and that the specifics of that example could have been addressed under current law lead us to further encourage you to vote ought not to pass on this bill before you today. Thank you so much for your time, and I'm happy to answer questions.
Thank you very much. You hit the 3-minute mark exactly. Now I have to figure out how to turn off my phone time. But
I can help you with that.
I see that there Representative Moriarty has a question, and I'll figure out my phone timer while he asks his question.
Okay, thanks, Madam Chair. Ms. Melnick, would you agree that all of these uncertainties could be resolved if the decedent had simply had a will prepared?
Absolutely. And, again, I think the problems that are created by this bill would be more than under current law, and that there's certainly, the law is structured in a way for people to address the circumstances that were laid out in the example.
And just one more question. I see this really as sort of gender neutral and so forth. And so if a person appoints a partner in a will to be personal representative, would you agree that there are no gender or gender identity issues that come into play?
Yes, I would agree with that.
So the message is, and this has been around for decades, if not centuries, get a will.
Yes, get a will. And I think, you know, in the circumstances where there isn't a will, that the sort of backstop follows the majority of circumstances where the intent would be of the decedent. And I believe that's the way that the law is structured currently.
Thank you very much. I see Senator Keim, you may proceed with your question.
I have a question. I'm actually raising a point of order, and in a public hearing, generally, we ask questions of people rather than interject our own opinions on the bill or have discussion between members themselves. So I just wanted to remind committee members of that. We have time during a work session to discuss our own opinions, but right now it's really just a matter of gathering information.
Thank you. That is a good reminder. And we will have ample time during the work sessions on all of our bills to discuss among ourselves. Let's see, Representative Babbage, do you have a question for Ms. Melnick?
Thank you very much, Madam Chair. Can you hear me okay? Ms. Melnick, hello, and thanks for being with us today again. Yeah, Representative Reckett mentioned a registered domestic partner being in a different part of the law, spouse and registered domestic partner. I'm unfamiliar with that. I mean, I haven't looked at this carefully enough to know all about that yet. But with regard to the definition of domestic partner that you again shared with us, has that definition been clear enough in its application in the last 15 years, in your opinion?
Yes. Again, I think the fact that there was not a lot of testimony in support of this bill supports that. And I think there are others who may be present today that could give you more specifics. But again, you often ask, is there a problem that needs to be fixed here? And I think that, the answer here is no.
And my question really is to the appropriateness of long-term domiciled and the specifics of the current definition being applied, and you're thinking that definition has adequately been in the law.
That's my understanding and impression, and I hope that others, if they have a different feeling, could testify to that today. I know there's been some distinctions and discussion around registered versus unregistered. I just want to again reiterate the point that was made by Representative Reckett, that it's extraordinarily common for folks to share a home, share finances, share a life for lengthy periods before getting married or before registering. People might not even know about the existence of registration for domestic partnerships. So it doesn't mean that they should not continue to have priority under the law.
Thank you.
Thank you, Representative Babbage. Are there any other questions for Ms. Melnick? Not seeing any hands raised at this point, so thank you very much, Ms. Melnick.
Thank you very much.
We'll move on to the next person on the list is Leo Delicata from Legal Services for the Elderly. You may proceed, Mr. Delicata.
Thank you. My name is Leo Delicata. I'm an attorney with Legal Services for the Elderly. I have submitted some written testimony, and I would ask you to read it. I'm going to read a portion of it because it deals with a much more global issue, which is how the probate code, or at least my view of how the probate code looks at relationships and values relationships. And so it starts on page 2. As a general rule, the probate code gives spouses the highest preference to act as agents for the other spouse. This is not only because spouses have a unique level of understanding and appreciation for the other spouse's qualities, but because the relationship of marriage has always been highly valued as a fundamental building block of society. As our culture continues to evolve, relationships functionally equivalent to marriage have also developed. Domestic partnerships are an example of one that has been accepted and given a legal status. The definition of that relationship is clearly one that some adults have adopted as their primary life choice, or after they divorce or suffer the death of the spouse. Prior to the recognition of marriage equality, it was the only legally recognized relationship for LGBTQ+ individuals. Today, especially for older adults, marriage may not be financially realistic given the various penalties that affect Social Security benefits and other pension or revenue-related issues. If they develop a relationship with someone with whom they can be, quote, domiciled together under long-term arrangements that evidence a commitment to remain responsibly, indefinitely for each other's welfare, this will qualify as a domestic partnership and will give them a measure of legal protection. Some domestic partnerships, like marriages, have their challenges. Adult children or others may not be accepting of their parents' choices as they age and may have different expectations about how property still owned or controlled by their parents will become part of their inheritance. The drafters of the probate code understood these realities. So one of the themes that runs through the code is respect for the right of a person with capacity to make decisions that they believe are reasonable about themselves or their property. In that way, it recognizes that a person's autonomy has the highest value and should always be honored. The code offers help and provides guidance when a person doesn't have the capacity to make their own decisions, or if they die with or without a will. It's designed to let a person's values and preferences become known so that these vital personal indicators may guide how decisions about their lives or property should be made. The priority systems in the code are designed to bring those who have the closest understanding of a person's worldview into the decision-making role. In the case of the deceased spouse or domestic partner, as in the bill before you, the priority ladder expects that a surviving spouse or surviving domestic partner, by definition, will have an intimate view of what that person would want and would have that person's best interest at heart. This is not the only place the probate code has afforded domestic partners a status likened to a spouse and a priority over that it assigns to the heirs. A domestic partner has priority to serve as a guardian, conservator, healthcare surrogate, and a custodian of deceased's remains. While the duty of a personal representative or conservator do not involve the responsibilities or decisions that protect the lives of vulnerable people, they are still similar fiduciary positions that require a high degree of care in managing the property of the other. In both instances, knowing how another would act is important. The probate code adopted here. Yes.
I'm sorry to interrupt, but the 3 minutes has passed and I would just ask you to provide a concluding statement and then we'll move on to questions.
Well, I do have 2 sentences left.
Oh, perfect. Okay, go ahead.
Thank you. The probate code adopted here less than 2 years ago took many hours of work and discussion by this committee, PATLAC, and many interested parties. Disrupting this thoughtfully crafted system by changing priority positions should be done with care and with a strong and articulated reason for adopting a different public policy. In this instance, for this bill, we are unable to see a reason to change, and we hope you will agree. Thank you.
Thank you, Mr. Delicata. Are there questions by members of the committee for Mr. Delicata? I'm not seeing any. Thank you very much. And thank you for the extensive written testimony. And I don't know if you plan to attend the work session, but we would reach out to you if we had questions. Thank you. Next, I'll recognize Mary Bonato.
Thank you. Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary, good morning. I'm very grateful for the opportunity to be here and talk about this bill. I'm an attorney. I live in Portland. I work at a place called GLBTQ Legal Advocates and Defenders, and I've worked in Maine for many decades now. GLAAD opposes this bill and is not supportive of the changes that have been advanced either at the hearing today. Clearly, everyone knows LD 124 would alter the priority of an appointment for personal representative in the
Ms. Bonato, I think you inadvertently muted yourself. There you go.
I did. Thank you. Okay, I don't know where I was. All right, just to say then that we all know what LD 124 would do. It would reprioritize heirs over domestic partners in the priority list for personal administrators. There's a list and there's different categories. And just to be super clear, registered domestic partners are considered as spouses under the probate code, as has been talked about. So let's just take those off the table. We're talking about when there's not a registered domestic partner, but in fact, you know, somebody in one of the 10% of households in this state. Census Bureau estimates there are 52,000 households in this state of unmarried partners, some percentage of whom would meet that definition of domestic partner, the two people, unmarried, long-term commitment, taking responsibility for one another. Certainly not all of them, as we heard today from Senator Searway, but definitely some of them. So we oppose this for a number of reasons. First, the reordering is really in tension with the purposes of the probate code, and I think Attorney Delicata set that out really beautifully. I would just also say that a theme in the probate code is to try to assign rights and responsibilities and distribute property according to the assumed wishes of the decedent. And here, that principle supports elevating, in our view, domestic partners, unregistered domestic partners over heirs who could be, you know, somebody who's a parent, a sibling. Okay, I don't think it's me. Sorry, I'm back. It could be a sibling. It could be any number of, like, a great grandparent, a great grandparent. And those people may have no ongoing connection with the decedent. The domestic partner, by that very definition, suggests a current connection, an intertwined life, and as Ms. Melnick put it for Equality Maine, you know, a family of choice. So we think this, that domestic partners should remain where they are. The other piece I wanted to say is the job of personal representative is well suited for a surviving domestic partner because, again, they've had that interdependent and shared life. What a personal representative does is sort through a decedent's affairs and belongings and memories, inventories the estate, pays bills. You know, there's a whole set of responsibilities under Maine law, and it's also an opportunity for healing. And in that vein, I wanted to bring to your attention quickly the separately submitted testimony of John Bowker, 38, almost 40-year relationship with a man they met in Maine, traveled various places, came back to Maine to retire. Before they were able to marry or do anything else, one of them died without a will, and the brother came in expecting he would be personal representative. And in John's words, if I may very briefly, it would have been emotionally devastating to me if the law gave priority to my longtime partner's brother, with whom Glenn was not close, allowing him to undertake the many personal tasks associated with serving as personal representative, including inventorying our personal property, deciding what was joint, and so on. So I do think there are probably stories on both sides here. And again, this is a significant part of the Maine population, and no need really to disrespect these ongoing commitments that we have in our households. Thank you very much.
Thank you very much. Are there questions for Ms. Bonato? I'm not seeing any more, any questions. Thank you very much. The next person on the list is David Backer. And Mr. Backer, are you neither for nor against, or are you against? You're muted.
Sorry. Senator Carney, I will speak neither for nor against. So if there are
Yeah, let
more,
me put you on hold for just 1 minute. I just want to make a final call. Is there anybody else present in the electronic meeting who intends to speak in opposition to this legislative measure? I'm not seeing any, so Mr. Backer, you may proceed as neither for nor against.
thank you. And the reason I am speaking neither for nor against is because I am here in my capacity as chair of the Probate and Trust Law Advisory Commission, and the Probate and Trust Law Advisory Commission has not had an opportunity to meet to discuss this and formally take a position on it. But I do have observations that I would like to share that I think are consistent with some of the comments that you've already heard. You know, the example that we've heard that prompted LD 124 is an heir who had a bad experience with a domestic partner in the administration of an estate. Unfortunately, there are likely an equal number of cases where the domestic partner has had a bad experience with one or more heirs who unceremoniously ejected the domestic partner from the home where the domestic partner may have lived for years with the decedent. And as Ms. Bonato said, it's not uncommon for heirs to be somewhat estranged from the decedent and have no relationship with the domestic partner, or who perhaps don't approve of the domestic partner for any number of reasons. The reality is that people sometimes behave badly in an estate administration, and regardless of whether the domestic partner or the heirs have a priority, there's certainly the potential for incivility. But I think what's important to keep in mind here is that a domestic partner serving as personal representative who doesn't fulfill their fiduciary obligations to the heirs is subject to removal from that role. And is also subject to potential personal liability if they have breached their financial fiduciary obligations to the heirs. An heir that isn't mindful of a domestic partner's grief after the death of a decedent and acts with insensitivity has no liability to the domestic partner. So recognizing that a domestic partner faces potential exposure for breach of their fiduciary obligations as personal representative, and that an heir faces no similar exposure to the domestic partner, suggests that the order of priority is best left as it is, with the domestic partner having priority over the heirs. And as it was Representative Reckitt who correctly first pointed out that under Title 18C, a registered domestic partner is treated exactly the same as a spouse. So there's no reason to amend this section of the probate code to specifically reference a registered domestic partner. A registered domestic partner is already protected. And those are all of my comments. Thank you.
Thank you very much, and thanks for being so responsive to the time clock. At this point, I'll open up the floor to members of the committee who have questions. Representative Babbage's hand was up first, and then Senator Kine. Go ahead, Representative Babbage.
Thank you very much, Madam Chair. Thank you for all of this. I think the committee is aware, probably to a person, that small tinkerings with carefully crafted law could have chilling consequences. But I still need to understand a registered domestic partner and a spouse are considered equal before the law, but I'm not quite understanding what constitutes a registered domestic partner. Could you help me with that, Mr. Backer?
I can, somewhat. I can't tell you specifically, but to register as a domestic partner, somebody on this call will be able to tell us exactly what department or office of the state one registers in, but there is a form. I mean, it's a very simple one-page form to be filled out and signed by the partners where they declare themselves to be registered domestic partners, and it's filed with the state, and a certificate is somewhat like a marriage license. A certificate is actually issued. It's a very simple registration process.
So it is officially documented with the state, is what you're telling me.
It is absolutely officially documented, the same way a marriage is documented, by the issuance of a certificate. And without a certificate, you are not a registered domestic partner.
And is it done for the purposes that we're talking about today, or are there other reasons to be a registered domestic partner?
Well, certainly to gain the rights granted under the probate code to a registered domestic partner would be one impetus for doing it. But I think a lot of people probably do it for the emotional tie to their partner. Leo Delicata may be able to speak to financial benefits that registered domestic partners have outside the probate code that I'm really not conversant in. But,
thank you.
Yeah, and that may also be outside of the scope of the hearing on this particular bill, but thank you for pointing that out. Does that answer your question, Representative Babbage?
Yes, thank you much. Thank you, Madam Chair. I mean, the term registered domestic partner has been, tossed around as a potential inclusion to solve the alleged problem brought before us. So I just wanted to try to
We'll
understand.
have that information available. Yeah, we can have that available at the work session, because I think probably a number of committee members have that same question.
Thank you very much.
Yeah, thank you. Senator Keim?
Thank you, Madam Chair. Mr. Backer, what I'm curious about is, I mean, it was mentioned that there isn't much testimony here in favor of this bill, and I think we all recognize that who is here are, people that are paid to keep track of this type of legislation, and lots of times something small like this, seemingly small like this, kind of goes unnoticed by the general public who it will actually affect. And I have heard from other folks having this sort of same issue. And I think it comes down to, which is the clarifying question I asked Senator Searway, I think it comes down to the wording of long-term relationship seems a little ambiguous. How do you know, how does a regular person reading the law know where they fall in this lineup? And then every time, I mean, we're not a bunch of millionaires here in Maine. And so so the people that are looking at this are just, they've never hired a lawyer in their life probably. And now they're thinking, well, if I hire a lawyer, right, there's already that step, which seems a little big and fearful. Then they're hiring a lawyer and they've got to fight this. And then the money that they're fighting is, the estate is likely very small anyway. So is there any suggestion that you would have for language that would help clarify this better? I know we've talked about it before since I've been in the judiciary, but I think it's something that I've heard before and wondering if there's a way we can do it better. Would you have any suggestions around that?
I don't. The definition that we have of domestic partner right now to unmarried adults who are domiciled together under long-term arrangements to evidence a commitment to remain responsible indefinitely. I agree that there is certainly some ambiguity in a few of those words, but it's not uncommon for legal standards to have some measure of ambiguity. And I think you'd find it to be I mean, short of a registration process that it's either, there's a bright line, you're either registered or you're not. I think you'll find it to be an impossible effort to create a definition and a standard that is incontrovertible. I mean, you'd have to create a timeline. You know, do people have to live together for a year? Is it 5 years? Is it a month? I mean, I don't know how else you'd create a definition. I think the one we have actually works pretty well. Again, recognizing that it is not a bright line. I'm not aware of, I haven't personally been involved in any matters where that definition has been in controversy.
Thank you.
Thank you, Senator Keim. Is there anyone present in the well, first of all, do committee members, is there any final questions for Mr. Backer? I'm not seeing any. Senator Keim, your hand is still up. Is that just from the previous? Okay, great. Thank you. And then is there anyone else present in the electronic meeting who wishes to speak neither for nor against? Also not seeing any. So at this point, we will conclude the hearing on LD 124. And I wish to thank everyone for their participation today. And we will move on to the hearing on LD 159. But before we do that, I feel that it would be appropriate to take a 5-minute break. The committee members have been participating straight through since 10. So we will reconvene at noon. And I would just ask committee members to remember to turn off your cameras and mute yourselves, because this will continue to broadcast on YouTube during the 5-minute break. Thank you, everyone.
Come in. No.
Hi, everyone. It looks like we are in the process of having committee members return. Once folks are able to rejoin us, we will have LD 159, and that will be presented by Representative Wood. And it is an act to extend time limits for placing trust in trust status under the Maine Indian Claims Settlement. And we'll take that up in just a moment. And welcome, Representative Wood. Okay, I see that most of our committee members have returned and are ready to get started. So at this point, Representative Wood, you may proceed with presenting LD 159.
Thank you. Good afternoon, Senator Carney, Representative Hartnett, and esteemed members of the Judiciary Committee. My name is Barb Wood, and I represent House District 38, which is part of Portland. I'm here today to present LD 159, an act to extend time limits for placing land in trust status under the Maine Indian Claims Settlement. This bill extends the time limits for both the Passamaquoddy tribe and the Penobscot Nation to add to their respective trust lands under the act to implement the Maine Indian Claims Settlement. This bill changes the date to January 31st, 2030. For those of you who have served on this committee previously, you will likely recognize this bill. A version of it was brought before you in the 128th legislature, and the committee voted unanimously to amend and pass the bill. While the bill then passed in the House and the Senate, it was vetoed by the former chief executive, and an override was unsuccessful in the Senate. This bill then came before your committee again in the 129th legislature, but because of the pandemic, the work was left uncompleted. LD 159 is a fairly straightforward measure. The time limits discussed in this bill have been extended before, and it is important that an extension is once again granted. For these reasons, I ask the committee to vote ought to pass. Thank you for your time and consideration. I'm happy to answer any questions.
Thank you very much, Representative Wood. Would any of the members of the committee like to ask questions of Representative Wood? Representative Harnett?
Thank you, Madam Chair, and thank you, Representative Wood. Just so everybody who is listening or watching this hearing is clear, am I correct that the only thing your bill does is extend the time period? Doesn't change any of the geographic descriptions, doesn't change the bill, doesn't change anything in any other way. It simply provides more time for the tribes to exercise their rights.
That is correct. That is the only change.
Thank you very much.
Are there any additional questions by members of, I see 2 questions and I don't know who popped up first with a raised hand. Can you 2 let me know? No, okay. We're gonna go with Representative Babbage. You may speak.
I was trying to defer, but that's fine. Thank you, Madam Chair. Representative Wood, welcome. And similarly, I had a bill in to extend the time period, so I appreciate you bringing this before us. The only question I might have would be your action by merely changing these dates still restricts the tribes to purchase of land that was proposed as potentially purchasable back in 1980. Is that right?
Can you say that one more time?
In other words, the extension that you're providing is for the tribes to continue to pursue land
Right.
within the definitions of what land is available to be purchased as expressed in the land claim settlement of 1980.
That's correct. Some of the deadlines have actually passed on some, we've gone by on some of the parcels and some of the dates are looming. And so this bill is just solely to increase the time that's allowed.
Okay. Thank you.
And to also make all the parcels consistent with the same deadline.
Right.
Thank you. Representative Evangelos, you may proceed.
Thank you, Madam Chair. I actually lowered my hand because in reviewing some of the testimony, I got my answer to my question, but just so everyone knows, because I didn't until 2 seconds ago, the expiration date on some of the trust acquisition rights expire at the end of 2021. So that was my question, which now I've just answered. So, but if anybody else wanted to know when those dates expired, it's the end of this year. So thank you for that.
Thank you. That was a helpful clarification. Others may have had that question as well. Are there other questions for the bill sponsor? Not seeing any. Thank you very much, Representative Wood, for presenting your bill today.
Thank you.
At this point, we'll go to an opportunity for those who want to testify in support of this legislation. And my records indicate that Paul Tebow registered in advance to testify in support. So at this point, Mr. Tebow, you have the floor.
Thank you, Senator Carney, Representative Harnett, members of the committee. I'm Paul Tebow, the Managing Director of the Tribal State Commission, and I'm here to provide brief testimony in support of LD 159. I did submit written testimony, and I'm not going to repeat everything that's in that. So I'll just speak briefly. The time limit for placing land into trust has been extended several times, and MITSIC in the past has supported those extensions because they have promoted the purposes and effectiveness of the settlement. For the tribes, I think probably all of you know, the restoration and development of an adequate land base to support their people and their way of life was a critical element of the settlement. Extending the time limit will promote further economic activity that will mutually benefit the tribes, the surrounding non-Indian communities, and the state of Maine, that will mutually benefit the tribes and the state of Maine. Placing land into trust status also enables the tribes to practice traditional hunting, fishing, and gathering activities that have always been central to their identities and their cultures. And for all of those reasons, MITSIC does support the passage of LD 159. And that concludes my testimony.
Thank you, Mr. Tebow. And I see that we have a question by Representative Evangelos. Do you want to go ahead?
Say unmute. Yep, thank you. Hi, Paul. Nice to see you again.
Representative.
I noticed in Ambassador Dana's testimony, and I don't see her on the list here, so I'm going to ask you, that she indicated that that the nations have yet to attain the 150,000 acres set forth in the 1980 settlement. You know, and I was operating under the understanding that that was part of the original settlement, and that was an automatic. So can you explain to me what happened and why the nations still don't have that 150,000 acres?
Well, I would, I haven't seen Ambassador Dana's testimony, so, you know, with that disclaimer, and I defer to the tribes to speak in more detail, you know, about the hurdles they've encountered, or, you know, the reasons why all of the land has not been acquired. And I would also defer to Representative Newell, who probably, you know, can speak to that better than I. But it is my understanding, you're correct, that each of the tribes, you know, had the opportunity under the settlement to reacquire 150,000 acres. And neither of the tribes has at this point been able to regain all of that acreage. There are, as I understand it, a variety of reasons why that has been problematic. The result is that, you know, as of now, I don't remember the exact numbers, but they are both still substantially below the 150,000 level, and the extension of the time limits is necessary so that they can complete, you know, the reacquisition of the amount of land that was provided for in the settlement. And I would just, you know, restate, I think MITSIC's basic sentiment on this is that the restoration of an adequate land base was, you know, such a critical element, you know, of the settlement for the tribes that it really is important that these limits be extended so that the tribes have adequate time to complete the reacquisition of all of those lands.
Just a quick follow-up, and I'll sit tight and allow other people to weigh in on it. Was the original 150,000 acres, was that going to be trust lands or a different classification?
Well, it was the intention of the settlement was that those lands could be, you know, reacquired. Those identified lands could be reacquired and placed into federal trust. That was the arrangement under the settlement.
And lastly, I remember during our hearings last year that Representative Harnett pointed out that much of the land that was made available had been clear cut and had limited value. So these clear cut lands that were offered up, is that part of what the original 150,000 was?
Well, again, I would defer to the tribes, you know, to talk about that in detail. But yes, it is my understanding that some of these lands were, you know, timberlands that had, you know, had in fact been clear cut.
Okay, I'll sit tight. Thank you.
Thank you very much. At this point, I'd like to recognize Representative Newell because I believe that, that she would like to testify on this bill. And then at that point, Representative Moriarty, we will come back to your question.
Thank you, Madam Chair.
Thank you.
Good morning, Senator Carney, Representative Harnett, and other distinguished members of the Judiciary Committee. I am Tribal Representative Rena Newell from the Passamaquoddy Tribe at Pleasant Point. I am speaking today in support of LD 159, an act to extend time limits for placing land into trust under the Maine Indian Claims Settlement. It is my understanding that the Passamaquoddy Tribe has yet to reach the allocated 150,000 acres of land as indicated in the Maine Implementing Act, having only acquired approximately 90,000 acres. Therefore, I request your consideration in support of this bill to extend the time limits in adding trust lands for both the Penobscot Nation and Passamaquoddy Tribe through to January 31st, 2030. As a point of reference, I have included in the legislative, oh, I seem to have an issue with my testimony. I have included the legislative history of the Indian Land Claims Act with subsequent amendments, both proposed and enacted, as received from the Maine State Law Library, as well as a link to the Bureau of Indian Affairs that provides information related to the process by which land is placed into trust. I will be happy to answer any questions at this time, and thank you for your time and consideration. I would like to just kind of respond to some earlier questions, if I may, not having a complete full understanding as to the limitations as to why we haven't, in particular for the Passamaquoddy Tribe, been able to acquire up to the 150,000 acres as mentioned earlier. I do want to point out that the process by which fee land is placed into trust with the BIA is a timely process, and I did include that link that could be referenced. I cannot state for the record the amount of acres purchased by the Penobscots at this time. I would reiterate what Representative Evangelos had mentioned in prior testimony given during the 129th, during either the recommendations of the task force or before the Judiciary Committee in looking at LD 2094. There was a map, I believe, provided to the committee and or the task force that outlined the areas that have thus been purchased. Would there be any other questions?
Thank you, Representative Newell. And I apologize for not recognizing you first. I think that I had an outdated list, and please accept my apologies because by rights you should have gone just after the bill sponsor.
Oh, no, that's fine. That's fine to defer to Mr. Tebow. Thank you.
And I see that we have some hands raised, and I'm going to just recognize people. I don't know which bill proponent you intend to ask your questions for. So we'll start with you, Representative Moriarty.
Thank you, Madam Chair. I guess my question goes either to my colleague, Representative Newell, or to Mr. Tebow. And it's fairly straightforward. Is the matter of reacquisition of the acreage an issue of negotiation, purchase and sale type negotiation between the tribes and current owners of record.
Either Representative Newell or Mr. Tebow may answer that question. And just, this is a little irregular, but if one of you could please answer.
I would again once defer to Mr. Tebow.
Thank you, Representative Newell. Again, it's my understanding that that is, one of the problems that has, it resulted in the tribes, not being able to acquire all the lands, is that they do have to do individual negotiations regarding specific parcels. And again, I defer to the tribes. I haven't seen written testimony of the tribes, but I guess I would offer, on behalf of MITSIC, that if it would be helpful to the committee for me to follow up and have some communication with the tribes, and perhaps to submit additional information at the work session regarding the particular hurdles that the tribes have encountered in reacquiring the land. I'd be happy to do that.
Thank you, Mr. Tebow. We will take you up on that offer. It would be helpful to have that information for the work session. Thanks. Representative Babbage, did you have a question to ask? And could you let us know who you'd like to direct it to?
Actually, I'm not sure. I'm going to proclaim ignorance and ask for clarification. And if you could
go ahead.
I guess what my understanding is that the Penobscot Nation has purchased somewhat over 100,000, and the Passamaquoddy tribe somewhat less. They each have about 2/3 of the 150,000 that they were eligible for in the original settlement. What I'm asking, I guess, the purchases are made as fee land, and then they initiate a process by which to transfer those to trust land. If that's true, I'd just like that confirmed. But I'm unclear as to the role of the federal government in all of this. My understanding is the Department of Interior actually makes the purchase, but is that after negotiation, and is the failure to purchase the determined amount in the settlement, is the Department of Interior part of that calculus, or is it, as Representative Moriarty may have suspected, that it's merely a negotiating obstacle? Thank you. So my question really is, what is the role of the Department of Interior in this acquisition, and is that partially responsible for why we're not where we want to be? And purchased land from the land specified in the settlement are at first fee land, and then initiate a trust process. Those are my two inquiries. Thank you.
And if neither of you, Representative Newell or Mr. Tebow, are able to answer it, that's information we could get for the work session.
I once again, thank you, Madam Chair, but I would once again refer to the testimony that I provided in the linked information under the BIA.gov link, which outlines the process of application to fee to trust.
Thank you for that.
Again, kind of reiterating, the timeline is fairly lengthy in that process. It is an initial fee purchased, with then the application to have that land status changed to trust. I did kind of defer off screen to some other information, but if I could certainly bring it to the work session if that's helpful.
Is that helpful to you, Representative Babbage?
Yes, thank you. Thank you very much, Representative Newell.
Representative Newell, I think that would help us all. Thanks. Representative Evangelos, did you have a question?
Yes, thank you, Madam Chair. Representative Newell, do you know if part of the holdback on acquiring the full acreage that was outlined in the settlement had anything to do with the quality of land, such as clear-cut land that was offered up, and that the tribes may not have initiated a purchase and sales agreement because it takes 20 or 30 years for trees to grow back. Do you know if the quality of land that was offered up had anything to do with it?
Representative Evangelos, thank you for the question. I think as a side note, in trying to gather some information around this bill, it was mentioned to me that, following the settlement, the quality of those lands that were offered to the tribes to purchase were clear-cut lands. And as you mentioned as well, it does take a great deal of time to restore those lands. I think the question earlier, there has been, there is a state component, local government component in this entire process.
Thank you.
Thank you. Are there other further questions for Representative Newell? Not seeing any hands raised. Are there any up? Senator Keim, go ahead.
Thank you, Madam Chair. Yes, I just had one. So this continues the ability for the tribes to purchase lands until 2030 up to the already designated amount. Well, I was just wondering, is there some plan in place to be able to purchase these lands? And because the 2030 is a year set, so I was just wondering if there was some plans in place to move forward with this.
I'm not sure if I should answer that or if I should defer to Representative Wood.
Would you like to answer the question or because I don't think that there were any questions that had been asked of Representative Wood. So Representative.
Yes, I don't know what the plans are for purchase. I just know that the deadline was looming and we wanted to provide more time. That's all I can say on it.
It sounds like that might be an issue for us to address in advance of the work session if the answer is not available today.
Thank you. Yes, that would be helpful.
Other questions for Representative Newell or Mr. Tebow? All right, I am not seeing any at this point. I would ask, is there anyone else present in the electronic meeting who would like to speak in support of this LD 159? Matt Moonen, you may proceed.
Thank you, Madam Chair. Senator Carney, Representative Harnett, members of the Joint Standing Committee on Judiciary. My name is Matt Moonen. I'm a resident of Portland. It is an honor and a pleasure to see all of you, even though it's not in person. I will say, as a former three-term member of this committee and a former chair of this committee, I am very intimately familiar with the rule that former members are supposed to bring tribute in the form of food. And I apologize that I am unable to do so, but I look forward to the time when we can all be back together in person, and I promise I will bring tribute in the form of something delicious. I wanted to
testify on this. I'm not being paid by anybody to be here. I'm only here in my personal capacity because I do have a history with this bill. This bill, I first saw it 4 years ago when then Representative of the Passamaquoddy, Matthew Dana, brought this bill forward to the Judiciary Committee. Senator Keim and I were the co-chairs of the committee at that time, and it dealt with both the acreage and time limits when he brought the bill to us. This committee did reach a bipartisan and unanimous agreement in 2017 to extend the time limits to allow the Penobscot and Passamaquoddy to continue to acquire land and put it into trust. At that time, we extended it out 8 years, so from 2017 to 2025. So this bill is modeled on that bill because this extends it 9 years, which is approximately the same from 2021 to 2030. Unfortunately, as you heard, the previous chief executive vetoed that bill, even though we did get a unanimous bipartisan report on it. His rationale for that veto was that the settlement can never be negotiated or amended again. I don't think most of us would agree with that rationale. As you've heard, in fact, the time limitations have been altered several times. So it's already been amended multiple times in the past. Because that bill did end with a veto, I brought it back 2 years ago. I was the sponsor. Unfortunately, the Judiciary Committee for the entire 2 years of the 129th legislature did not hold a public hearing on this bill, which is a pretty extraordinary step to take, to refuse to hold a public hearing on a properly introduced bill. So I want to thank Senator Carney and Representative Harnett for holding this hearing. And you know, as you've heard, this really only deals with the time limits. I will point out from past testimony from Representative Dana, at that time, he pointed out that the Holton Band of Maliseet and the Aroostook Band of Micmacs have no time limits at all for putting land into trust. So I think if you wanted to really achieve parity across all of our native tribes, you could amend this bill to eliminate the time limits altogether for both the Passamaquoddy and the Penobscot. I think that would be the most fair thing. However, I did vote for that bipartisan and unanimous compromise 4 years ago. And, you know, I feel like it's a thing of integrity to stand by your vote. And so if you feel that doing an 8 or 9 year extension is the way to achieve some bipartisan support, I think anything would be welcome. The other thing I want to point out in the text of the bill is that the failure to act on this over the last 4 years has actually caused the tribes to lose the ability to put land in trust. And I want to point you to a couple of specific places. If you look at section 1, which deals with the Passamaquoddy tribe, in part D, there was a specific tract of land that they had the ability to put into trust until 2020. So the failure to act on this bill last session actually caused that date to expire. And if you look at D1, there was an expiration of 2017, that has expired. D2 coming up, there is a looming deadline of 2023. So failure to act on this bill will cause that deadline to expire. So, you know, I understand and respect that this committee has much larger and bigger and more complex issues of tribal sovereignty to deal with in the coming months. And I'm looking forward to seeing how that goes. But in the meantime, passing this bill would stop the tribes from losing rights to put land into trust that they have right now. And I think we should pass this bill, finally get it done after 3 sessions in a row, and make sure that the tribes have the ability to put land into trust as they should. And I'm probably past my time, so I'll stop talking. Thank you.
Thank you very much, Mr. Moonen. And thank you for your promise of future tribute. I see that there are several committee members who have questions. Representative Evangelos, would you like to begin?
Thank you, Madam Chair. And, how you doing, Matt?
Very good, Representative. Nice to see you.
Nice to see you too. Just for point of clarification, last legislature, there were 6 or 7 sovereignty-related bills, including yours, and mine didn't get a hearing either. But it wasn't anything personal. We had LD 2094, and all of those bills got wrapped up into that. And there was a clause in the task force recommendations that was voted on either unanimously or by a 9-to-1 vote to do just what your bill wanted. no date, open-ended rights to acquire lands within the 150,000. So I just wanted you to know that this bill and another bill that will deal with where we left off last August, the Judiciary Committee did vote to send 2094 to the floor. It was a divided report, but it was a good sized majority. So I want you to know that your efforts didn't go unheeded, and they were part of the overall recommendations. Thank you for your work.
May I respond to that? I don't know if that was a question, but I would still love to respond.
Sure. I mean,
Yes,
I'm not
you
the
may.
chair.
Yeah, Representative Evangelist, I certainly appreciate your point. And as I said, I was aware of the larger tribal sovereignty issues and the larger bill going on. You know, I still think I was a duly elected representative at that point, as were you. And I still think it's inappropriate to refuse a public hearing on a bill introduced by a duly elected representative.
I'll keep that in mind going forward.
I'm sure you will.
I see that Senator Keim has a question for the speaker. Go ahead.
Thank you. Nice to see you, Honorable Moonen.
You too, Madam Co-Chair.
So you actually mentioned something that I had forgotten, or maybe it went over my head at the time. So only 2 of the tribes have limits on the land, on when they can purchase lands, and the other 2 tribes have no limits.
So I will admit it's been a while since I've thought about this. So I was reviewing past testimony, and that was the testimony of Representative Dana. So I would defer to the tribes and certainly your capable analyst to verify that, but that is my understanding.
Okay, great. And so then I'll just make a comment that for the work session, I would like that information. And I imagine there's probably a significant difference in the amount of land that the other tribes can purchase. So if we could have that information as well for the work session, that would be great. Thank you.
Thank you. We'll get that information. I see a couple of more questions, Representative Reckitt and then Representative Newell.
Hi, Matt. Good to see you. I have a question about the barriers to purchase. I understand that there's the timeline as a problem, but is it not true to your understanding, as it is sort of to mine, which is to say I inhaled, I can't tell you how much sovereignty stuff and reports and everything else 2 years ago into my head. So whether it's still stuck there and accurate is questionable probably. But the piece I want to know is, it looked to me like the other barriers that could be happening in addition to the timeline are local authorization of the purchase by, if it's within I think an organized town or whatever, anything besides unorganized territories, you had to have the okay from the local jurisdiction. And it seems to me that that would be another barrier that has been keeping this moving slowly. Is that accurate?
Thank you for the question, Representative Reckitt. I will admit I'm not an expert on land acquisition, but certainly local opposition. I would think the price, could be a barrier, and the amount of money that the tribes have available. And I heard the question earlier about needing a plan from them, but I would say that's not really appropriate here. We had a deal that they could acquire up to 150,000 acres, and frankly, I think it's their business how they go about doing that. And it's their business to negotiate with local people and their business to negotiate the price. And I just think we should leave it simple.
Thank you.
Representative Newell?
Yes, thank you, Madam Chair. Representative Moonen, thank you. Perhaps I should have deferred to you in the beginning, but thank you for bringing about all those reminders. And I would support your statement relative to Micmac and Maliseet in not having term limits. I spoke with Chief Sabatis on this bill, recognizing the difference. And I also spoke with Chief Peter Paul on this bill as well as some other bills that are coming up. One of the questions I found interesting that came from my conversation, from Chief Peter Paul, was basically why are there continuing deadlines? Why not a full extension? So I appreciate your comments in bringing about parity with the other tribes in, not having deadlines. So thank you for that. I can give an example. I may have to go off screen, but to what Representative Reckitt mentioned, there was an example, a benefit of putting fee land into trust, as outlined if you were to refer to BIA, has a number of benefits, and Mr. Tebow mentioned it. One of them, are housing opportunities to build houses. So there was a local situation where, again, I wouldn't necessarily I wouldn't define it as an obstacle, but certainly it presents a challenge when you do have to go to your local town or where you're going to purchase, because it requires the language reflected, coming out of the Maine Implementing Act in regards to land acquisition is you have to receive a yes, an affirmative from that town or area that you're purchasing land from. So that can certainly hinder the process. So we were able to put local land into trust to expand our housing development. With such, there was a significant amount of money that had to be paid to the town in addition to the land purchase, the prior land purchase and the process of putting into trust. So those might be some additional limitations when we talk about, what's limited this acquisition, since 1980. I would like to add, though, that any additional information could possibly be brought forth, during the work session. And I want to mention, Ambassador Dana did, provide written testimony. However, she's in and out of meetings, and she did want me to indicate that she is more than available to be present at the work session. So I just wanted to note that for the record.
Thank you. That's helpful. We will ask her to attend the work session as well. Go ahead.
If I may, thank you, Madam Chair. Representative Newell, to your point about the time limits and parity, I want to thank my representative, my successor in the House, Representative Wood, for sponsoring this bill. And as I said, I just asked her to put it in as it was before. But the bill is now in the possession of your committee. So it is yours to do with as you will. And if you decide that 2030 is not the right date and you want to change it to 2050, that's your decision. Or if you want to get rid of the time limits altogether, that's your decision. So I wish you luck in that process.
Thank you. Are there any other questions for the Honorable Matt Moonen? Yet, Representative Harnett, go ahead.
Welcome back. Welcome back, Matt. It's very good to see you. Not so much a question as so the record is clear. The consensus recommendations regarding land acquisition by the task force were all unanimous. And it was to eliminate not only the timelines, but also to eliminate the veto power by state and local communities. So I just wanted to make sure that was clear.
Thank you, Mr. Chair. I'm aware that I didn't follow that bill and the recommendations nearly as closely as many of you. So that's helpful to know. Thank you. And nice to see you too, Mr. Chair.
And we will have the recommendations of the task force available also at the work session. I think they're already posted on the judiciary website as well. And Representative Babich, did you have a question?
I did. Thank you very much, Madam Chair. And I also didn't want to pass up the opportunity to welcome back our former chair. but he is knowledgeable on the subject too. My understanding is that the settlement happening in 1980 provided for 150,000 acres for the two major tribes, and the Maliseets at a later time was interested in purchasing land, and although I wasn't actually aware of a deadline, their 5,000 acre negotiated came later, and so I think the settlement being early, as a matter of fact, pioneering nationally, is one of the reasons that they had a deadline early on. I guess what I would like to ask Representative Moonen, the Honorable Moonen, is the purchase of. I guess what I'm asking is the bill, which is pretty straightforward, helps us to understand the acquisition of land that can get into the fee to trust conduit for the tribes. Does it impact at all, or is the tribe's ability to purchase land outside of the specified areas affected at all? Do you understand what I'm saying? There was a negotiated settlement with specified areas, and I'm just wondering if the two tribes, or any tribes, want to purchase land as a tribe. I suppose individuals always have the right to purchase land, but if they want to purchase land as a tribe, can it go into the fee to trust, or is it a separate category other than what we've defined in the settlement? Does that make sense to you, what I'm trying to figure out here?
I think so, Representative Babbage. And again, I would defer to your analyst who's been working on these issues for many years. But I think, and I'm sure she can correct me if I'm wrong, but I think my understanding is no. And as you said, anyone can purchase land. I think the distinction here is the Settlement Act lays out specific tracts of land that the tribes can acquire and then put into trust with the federal government. And so, yeah, anybody can purchase anything, but it has to be within these designated tracts in order to be part of the trust. But again, we're verging very dangerously near the edge of my knowledge on this. So.
Yeah, and I think there are some questions today that we'll have to take up at the work session. I would encourage members of the committee to email either the chairs or our analysts with those questions. Representative Evangelos, did you have a question you'd like to raise?
Yes, thank you, Madam Chair. A question for Representative Newell. Representative Newell, my good friend from Kennebunkport just referred to the 1980 settlement as pioneering. I'm going to ask you, what exactly was pioneering about an offer by the state to allow you to buy land you once owned as the indigenous original inhabitants of Maine, and land that was severely cut over? I just don't want the wrong impression being left today that what happened in 1980 was anything but unjust. So would you respond to that, please?
Thank you, Representative Evangelos. I think my comment to that will be this, that I personally have come to learn that the Maine Implementing Act that followed the Land Claim Settlement Act of 1980 has imposed great restrictions to the Passamaquoddy tribe and the Penobscot tribe relative to a number of areas. So I would leave it between the Passamaquoddy tribe. I don't want to speak for the Penobscot Nation. However, in the original Land Claim Settlement Act, it was the Passamaquoddy and the Penobscots. And then, as you well know, Maliseets followed after. However, there is, a significant need, as indicated in the 129th, relative to the task force meetings and the testimony that has been provided before this Judiciary Committee in regards to much needed change to the land claim settlement, and in particular, the Maine Implementing Act. I think the list is quite long, and this is only one particular area that needs to be addressed as far as bringing about, you know, those changes that in my opinion have absolutely limited since 1980. We're in 2021. It's my understanding this document was and is, you know, subject to revision based on the relationship between the state and the tribes. What was mentioned earlier, as far as the number of bills that were submitted during the 129, submitted on behalf of the tribes by not only, you know, by representatives and senators, really brought about, you know, everything that occurred during the 129th in bringing back the conversations between the tribes and the state. It was mentioned, you know, I tried to reconcile those bills that were not referred to committee. And yes, there may have been some discussion that some of those bills were not provided a committee hearing, a public hearing, this one in particular, based upon, you know, the establishment of the task force. And perhaps I referred to those bills as kind of being balled up, placed to the side while the task force underwent its review, which later turned into LD 2094, the larger bill based on the recommendations from the task force. But I also want to say that included in that larger amount of bills that were submitted on behalf of the tribes included the Violence Against Women Act bill. And that was tied up. That bill itself was tied up in the bundle of bills that were not being presented to the committees. And that was to be separately addressed from the larger, what we now know as LD 2094. So I do recall being at a tribal leaders meeting in Old Town under Chief Francis of the Penobscot Nation, and this conversation come up in regards to the VAWA reauthorization and its lack of it being recognized in the state of Maine. So we did have a conversation about it, and that request was made to leadership to allow that particular bill to be referred out to the committee, thus holding the public hearings and the testimony. And then we now know that it went through the process and it was signed into law. You know, so I do recall, you know, as mentioned, that some of the bills that were submitted early in the 129th did not go through the process. So I appreciate, you know, Representative Moonen, you know, bringing back some, you know, you know, thoughts, you know, yeah, from that time. I appreciate your question, Representative Evangelos, and I certainly hope I answered it.
Thank you very much, Representative Newell. Representative Babbage, did you have a question?
I have a statement that's very, just to clarify. I wasn't commenting. It was in reference to something that was said that I said, though, Madam Chair, and I'd just like to clarify for the record that in my experience as a high school teacher, the Indian land claim settlement in Maine actually got a full page on a major United States textbook for the first time recognizing the legal claims of Indigenous peoples. And that was pioneering. And so that's to what I was referring. Thank you so much.
Thank you very much. Do we have any other questions for the Honorable Matt Moonen, who is here before the committee today? Does not look like it. So thank you very much, Matt, for appearing before the committee and for your testimony and your answers.
Madam Chair. Good luck to you all. Nice to see you.
Is there anyone else present in the electronic meeting who wishes to testify in favor of LD 159? I'm not seeing any hands. Is there anybody who wishes to testify in opposition to the bill? Not seeing any hands. Is there anyone who wants to speak neither for nor against the bill? And again, I'm not seeing any hands. So at this point, we will close the hearing on LD 159 and we will move on to the hearing on LD 132. And LD 132 is entitled An Act to Implement the Attorney General's Recommendations on data collection in order to eliminate profiling in Maine. The sponsor is Representative Rachel Talbot Ross, and she is here today. And welcome very much to the committee, Representative Talbot Ross. You may proceed.
Thank you. Senator Carney, Representative Harnett, and esteemed members of the Joint Standing Committee on Judiciary, I am Rachel Talbot Ross. I represent House District 40, and I serve as the Assistant House Majority Leader. I want to thank you for the opportunity to come before you to present LD 132, an act to implement the Attorney General's recommendations on data collection in order to eliminate profiling in Maine. It is wonderful to see all of you again. And as a former member of this committee not too long ago, I will try to find a way to get some chocolates or sweets to you, as is tradition. And I know I'm in good company because Representative Moonen also owes you a few treats. So today's a good day to be on Judiciary. It is important to know that I do not approach the issue we are going to discuss today from just the role of a lawmaker, but one that has personally impacted me as a 9th generation African-American Mainer who has been traumatized by bias-based profiling in our state. This matter is near and dear to my heart. Beginning in 2009, I was fortunate to co-chair the Advisory Committee on Bias-Based Profiling by law enforcement officers and law enforcement agencies, along with then Department of Public Safety Commissioner John Morris. I know that my colleague, Representative Tom Harnett, who co-chairs this committee, was also a member of that advisory committee. So I want to acknowledge that. I have been involved in this work for several decades, over 20 years, and I am proud and grateful to present LD 132 for your consideration today. LD 132 requires law enforcement agencies to collect data on traffic violation stops, including the race, color, ethnicity, gender, and age of the person stopped and the outcome of the stop, beginning July 1st, 2023. The bill requires that agencies report this data to the Attorney General, who will report back on his findings annually before the legislature's Judiciary and Criminal Justice and Public Safety Committees. I want to begin by saying that this bill is not intended to open up a debate about whether profiling is a problem in Maine. Again, I want to say that this bill is not intended to open up a debate about whether profiling is a problem in Maine. Instead, this measure recognizes that we do not have access to the objective data on the subject, and it gives the Attorney General the tools he has recommended we create in order to compile this data moving forward. For a little background, in 2019, the legislature directed the Attorney General, in consultation with stakeholders, to explore available techniques for the collection and compilation of profiling data, and then report his findings back to this committee. Attorney General Aaron Frey delivered his report to this committee on March 16, 2020, just as COVID-19 hit Maine and the legislature moved to pass urgent pandemic-related legislation before adjourning. The Honorable Craig Hickman submitted legislation to implement the Attorney General's recommendations last summer. This committee convened to consider it and ultimately voted unanimously in support of then Representative Hickman's bill LD 2168 at the end of July 2020. However, because the 129th legislature did not return to session between that vote and the end of the 2-year term, we were unable to advance the bill beyond committee. As drafted, the bill is currently the same as the one supported by this committee last summer. That said, I am offering an amendment today, which has been emailed to you and is also attached to this testimony. The amendment strikes the section of the bill beginning on page 2, line 22. As amended, the identifying information collected as part of the data regarding law enforcement officers will be available to the Attorney General. Again, the information collected as part of the data regarding law enforcement officers will be available to the Attorney General. I believe this is an appropriate and necessary in light of the Attorney General's role as the chief law enforcement in this state. The amendment does not change the fact that personally identifiable information regarding the person stopped may not be reported to the Attorney General, nor does it change the fact that personally identifiable information regarding the law enforcement officer will not be included in the Attorney General's report. I want to thank you for your consideration, and I would be happy to answer any questions you have for me. It's truly a pleasure to see each and every one of you today. Thank you.
Thank you so much, Representative Talbot Ross, for presenting this bill today. And thank you too for your reminder that the focus of our conversation and questioning today is really about the gathering of data and not about whether racial profiling happens. That is a good reminder to us as a committee. And with that, I will open it up to questions of the bill sponsor from members of the committee. And I do not know whose hand was raised first because I was taking notes. The three who have hands raised, representatives, can you just indicate to me who raised their hand first? Doesn't seem like anybody knows. So Representative Reckitt, why don't you proceed, please?
Thank you. I'm sitting here staring at the original bill and the proposed amendment, trying to figure out on the fly what exactly is the difference. And it looks to me, and I could be way out to lunch on this, which is where I'd like to be, I have to say, is the data that's collected is the same as it would have been under the original bill, but that the identity of the officers involved is only shared with the Attorney General. Is that what the substance of this is?
That's correct. The original version of the bill made confidential both the law enforcement officer and the person stopped, made it protected information from the Attorney General, from the information that goes from the law enforcement agency to the Attorney General's office. This amendment says that the name of the law enforcement officer should go forward to the Attorney General's office, but will not be included in the annual reporting that happens to this committee, into criminal justice and public safety, and therefore the public. It does not, it's simply, Representative, it simply says that the information of the law enforcement officer does proceed to the Attorney General, but it's not included in any of the reporting.
Thank you.
Representative Evangelos, do you have a question?
Yes, I have a couple. Thank you, Madam Chair. Good afternoon, Representative Talbot Ross. How are you today?
Good, thank you. How are you?
I'm doing good, thanks. I know that you've done a lot of work around the area of accountability and transparency on a variety of these issues. And I just wanted you to weigh in for a second regarding what your vision is about where, in this bill included, where we should be heading as a committee around the area of accountability and transparency when it comes to law enforcement.
So thank you for the question. As it relates to this bill, which is the only bill that I can comment on at this time, I believe that this step to include the law enforcement officers' information that goes only to the Attorney General is the accountability factor to answer your question, knowing that that information will not go forward in any reporting. But by giving the Attorney General the information on the law enforcement officer, it allows the Attorney General's office, unlike our current system, which only allows the Maine State Police, it will allow the Attorney General to be able to further analyze if there's any pattern or practice by a particular law enforcement agency or an individual law enforcement officer in the findings. So in terms of this bill, Representative, that is the place of transparency and accountability.
Thank you. And lastly, regarding racial profiling incidents, I just wanted to ask you, did you have an opportunity this morning to see the video in the Portland Press Herald? And I'd like to know if you had a comment on it. I'm
just going to raise a point of order, and I am sorry to interrupt your answer, Representative Talbot Ross, but this hearing today is about this bill, and as the sponsor suggested to us, that it's really about collecting data and whether we're going to move forward this measure to collect the data. And so with that, I would ask Representative Talbot Ross if she would like to answer the question, but just encourage you to be, to all of us to be focusing on the bill at hand. Thank you.
Oh, thank you, Madam Chair, and thank you, Representative, for the question. I will tailor my response given the direction from the chair. I did see the article and have been following along on the issue and believe that it is appropriate for an investigation into the matter to take place.
Thank you.
Representative Moriarty. Representative Moriarty, you are muted.
Of course I was. I'm sorry. Thank you, Madam Chair, and good afternoon, Representative Talbot Ross. I have three questions to ask with the permission of the chair. First of all, there's a distinction in my mind between a traffic violation and a stop for a traffic violation. And both terms are used. And I wonder whether you intended to be more inclusive and refer to all stops or only stops that resulted in violations or charges.
Well, thank you for the question. As you can see in the bill, we, under the information collected, subsection 4752, what it says is that following regarding traffic violations occurring, the number of persons stopped, and the nature of the alleged traffic violation that resulted in a stop. So I believe that this bill makes it pretty clear that what will happen regardless of whether a citation is issued, whether through a ticket or a summons, that the incident itself, the stop, will be recorded. All stops will be recorded.
Well, if a stop just results in a verbal warning or something far less than an allegation of a violation. Do you think that that falls within the scope of the bill?
I absolutely do, because we know nationally, and we have data here in Maine, that pretext stops that could be something as minor as a tinted windows does lead, first of all, these pretextual stops are disproportionate. 20% less likely to happen for white drivers as they are for black drivers nationally. And that pretext stop is usually what bias-based profiling occurs. So if we don't record, Representative, what happens for every stop, which could have been motivated by bias identification, then we're not going to collect the data that we need in order to eradicate bias-based profiling. It's the stop that is critically important to understand. And the stop could be based on a perception of a particular demographic characteristic. So we must include a record of each stop in order to capture that data. If a ticket or a citation summons is issued, as you know, that on each of those forms, there's already a category to record race and gender. So we capture that information on any ticket. What we don't do is capture that information on a stop. And so that's why this bill is aimed at capturing all the information on stops so that we can get objective data to then see if any bias-based profiling has occurred in the nature of that stop.
I'll leave the issue simply by commenting that I agree with you on pretextual stops, but that I personally see an ambiguity in the current language as to whether it broadly applies to all stops or only those resulting in violations. I'll stop there and say nothing further. The next question I had was relative to the point that the officer must make personal observations and perceptions. Now, many stops result in a request for production of the license and registration. And of course, when you go to someone's license, you see both gender and date of birth. So why wouldn't you use the license as the source of information for gender and age?
Because the business of profiling is in the perception, not in the factual. We're not at the profiling is done because of a perceived demographic characteristic, perceived identity. And so it is not necessary to ask for that information, because then that absolutely negates being able to capture the perception. And that is the business of profiling, based on perception and stereotype, if you will. I hope that answers your question.
Yes, I think it does. And then finally, can you distinguish for me the difference between race and ethnicity as used in the bill?
Absolutely. Thank you for the question. Race, as this bill picks up and is used legally, I believe, follows the protected classes as defined by the federal government. And ethnicity would be Hispanic or non-Hispanic.
Is that the only choice regarding ethnicity?
Well, with the federal government, according to the EEO categories of definition that we collect information on, according to the census, from my understanding.
All right, so just to illustrate, if I were stopped for speeding, an officer would not be required to speculate on my ancestry or ethnicity or anything like that beyond the Hispanic, non-Hispanic standard.
If you were stopped for speeding, you would be probably issued a ticket, and the officer would be in their rightful position to ask you those identifiers. And they would also pick that up off of some of that information off of your driver's license.
Well, okay.
I hope I'm answering the question. If it's a traffic stop for speeding, then you're going to be issued a ticket, and the ticket, I don't know if you've seen them, but they do have categories for where the officer can record that information and ask you for that information.
Suppose I'm stopped and just given a warning and there's no ticket. I just wondered, is an officer required to speculate regarding my national origin?
No, the officer is not asked. The officer doesn't speculate that at all. There is probable cause to ask you those questions and record them on the citation. I don't know if I'm answering your question the way that you'd like for me to, but the only way I can.
Representative Moriarty, I would like to have the floor for a minute. It's a little awkward when we're in the electronic meeting format and we're not all together in the committee room. I just wanted to let you know, and I'm going to ask you to hold your questions because the sponsor could be available for the work session, but we have over a dozen witnesses who wish to speak regarding this bill. And we have had witnesses who have had to cancel their desire to speak, even though they were in attendance earlier, because the meeting has been pushed back quite late in the day. So at this point, for members of the committee who want to ask questions, please restrict yourselves to one question that relates specifically to the bill. And then what we'll do is hopefully we will be able to finish up our questions of the bill sponsor, who again will be available for the work session. And then we can hear from some of the other witnesses who wish to weigh in and actually might be able to answer some of these questions a little bit better, particularly with the regard to the nitty-gritty of the ticket writing. So with that, Representative Evangelos, do you have a question for the bill sponsor?
Actually, Madam Chair, I have a question for you. If questions are going to be entertained as to questioning the reasons or the scope of the bill, why aren't representatives and senators allowed to enter evidence into the record as to why the bill is necessary?
That was the request of the bill sponsor, and I thought that it made a lot of sense because this is such an important bill. And if we take this opportunity to really fully vet the bill and focus on the bill, then I think that we do justice to the hard work that the sponsor has put into the bill. And that was the basis of my recommendation, that we focus on the bill because it is very important. And I want to make sure that we really evaluate the bill and hear from those who have come before the committee today.
Sure, I understand, but I don't understand why the hard evidence that's emerging out there that justifies the importance of this bill can't be entered into the record. And I'm going to raise a second objection. I've never participated in a legislative public hearing where the chair is restricting the members of the committee from asking questions. I'm sorry about the timeline. I mean, we started at 10 o'clock today and it's only 1 o'clock. We've gone 7, 8, 9 hours in judiciary in the past. Every member has always been allowed to ask their questions and without restriction. It's always been honored. And I just don't understand your last statement about shutting committee members off. And I hope the rest of this committee will, make their feelings known about this, because it's becoming a pattern, and we have a job to do, and we have to ask our questions. And I don't feel we should, any of the members, even the ones I don't agree with, everyone has a right to ask their questions. So we have to invest the time to make that happen. I'm sorry, it's just the way it is. It's the way every other committee has ever run.
I think we're in agreement, Representative Evangelos, that we have a job to do. We have bills to have hearings on, And I think it is really important for us to focus on the bills that are before us. And I appreciate your comments, but again, our job here is to do a hearing on LD 132, and I think we need to proceed with that. So if you had a question about the bill that you wanted to ask the sponsor, please go ahead, and otherwise we'll move on to another question from a committee member.
No, I just think that every member of the committee should be allowed to ask the questions without restriction.
Thank you very much. Representative Poirier?
Thank you, Madam Chair. And my question, first of all, I do think the importance of eliminating profiling in Maine is a very important topic. But I do question how we're going about getting this data. Having officers put in a position that they're asking these questions or having to think of these things in their mind and make these generalizations, is that not profiling in itself? Are we not asking these officers to actually profile?
So thank you for the question, Representative. Absolutely not. What we're trying to capture is if the profiling is taking place. So asking the question of some of these characteristics, we already do. It's already, if you look at a traffic violation form, the Attorney General is here and he can give you a whole lot more information about it than I. But we already capture this information based on perception. Not only when you do have a traffic violation, it's a category that's recorded on the traffic ticket, and so the officer has to record that information on a traffic ticket. Now, I'm not sure if there are standard operating procedures in place that help officers ask that question, or if we do any training on how to ask the question around gender identity, race, ethnicity, age. But we're already capturing that information in numerous ways, whether it's a civil violation or alleged criminal violation. So, Representative, we're already capturing that information to some degree, and by asking it is not perceived to be a personal bias of the police officer. What we're trying to do in this bill is capture the perception of those characteristics as it results in a stop. And so it is not to answer your question, to ask the question of someone's race, ethnicity, gender identity it would not then make the person asking the question to be sexist or racist or any other. You can't conclude that by asking the question, because we already do.
Madam Chair, could I please ask a follow-up?
Yes.
Representative Talbot Ross, do you think with this legislation going through, since the officers will know what this data would be collected for, do you think the data would be accurate or skewed?
Well, I do not. So I'll just remind the representative that it's currently against the law to profile. That law passed last session. There's already a prohibition against racial profiling. So this bill is limited to the collection of data related to that. And the only way to collect the data is through, I believe, through this bill. Is we asked the Attorney General, after we passed the law prohibiting racial profiling, to come up with a system through rulemaking that would allow us to capture some data and to begin the analysis of that data and to report that to this committee along with criminal justice and public safety on an annual basis. So it is a prohibition now, and this bill asks the Attorney General simply to create a mechanism in order to collect objective data in which can be analyzed and then reported back to this committee. That's what this bill does. This bill is not debating if racial profiling is taking place. It's saying it's prohibited by law currently in the state of Maine. And now we want the Attorney General to implement a mechanism in which to enforce that law.
Thank you very much.
Senator Keim?
Thank you, Madam Chair. Welcome, Representative Talbot Ross. Nice to see you. So I have some questions. I'm trying to create scenarios in my mind as I walk through this bill. So if an officer makes a stop, someone, you know, runs through a red light or whatever it could possibly be, in that moment, they may or may not be recognizing who's driving that car. I mean, it's just a car. They may not have even noticed who the driver, any identifying information about the driver until they're actually pulled over. Is that right? Is that how you're perceiving this as well? Or are you thinking that they will be able to answer these questions based on what they see before they put on their lights and pull someone over?
Well, I'm not a law enforcement officer, so you could probably ask one of them soon. But this is just capturing the perception, whether once they go to the window or before they pull the car over, this is capturing that perception of the stop. And so law enforcement does that all the time. And this bill only asks them to capture what their perception is, whether it amounts to a ticket or it doesn't. That's not really the case. Is to capture what their perception is at for that stop.
So if they're capturing,
did you have a follow-up?
Yes, I have a couple of follow-ups. I'm trying to follow a line of reasoning here.
Okay. Why don't you do one more follow-up question, and then we'll go to Representative Libby, just to make sure that everybody has an opportunity.
And I would add that I believe that the Attorney General is prepared to answer some of these questions in more depth. So we may want to hear from him soon.
Yeah, and I would just also observe that we have representatives of law enforcement agencies and as I said, a dozen or so other witnesses who may be able to answer the questions with a little bit more information.
So I was asking these questions because I think the sponsor is the best one to answer the thought process behind why a bill is there, and how they're assuming that this is going to play out in real life. And so that's why I think it's important to kind of ask this of the representative, the sponsor. So I guess then when a person makes a stop, when an officer makes a stop, the data that they collect is something that is already provided to them on a driver's license. And if I'm wrong on that, I guess someone can correct me later. But then what we're asking is that they make assumptions on a person based on what they see, not necessarily what's on the driver's license. Is that correct? That's what you're asking for them to do?
Yeah, I would not use the word assumption. We're trying to capture their perception, so that would be my word. And some information is on the driver's license. Race is not on the driver's license, so some of this is their perception. Yes.
So, so then my follow-up to that is, but how is that different than profiling? Because I mean, if it were me, I would feel like then I'm then profiling someone and writing this down, and yet we passed a law against profiling.
You're not profiling if it's a legitimate stop. What we're doing is capturing we're capturing the perception of the officer during that stop, and that is not an act. That is, we're trying to record their perception of these characteristics that are suggested in the bill. If it's a legitimate stop, there's no cause for concern. The officer proceeds with writing the ticket or issuing whatever that citation is, and he records the perception of the individual who was stopped, and that information goes along to the Attorney General's office. Other information goes to the law enforcement agency and proceeds through the legal channels that way. But we are recording perception. That is the only way in which we're going to be able to determine if there was any bias in the stop, whether it generates the ticket or not. There's no other way to capture this information around bias-based profiling, but to do it this way, Senator.
At this point, I'll recognize Representative Libby. You've had your hand up for quite a while. Thank you for your patience.
Thank you, Madam Chair. I do have to express that as I am new to this bill, and a number of us are, in order to have a well-rounded picture of exactly what the bill is and does, I feel like it's imperative, as Representative Evangelos has said, that we have all of our questions fully answered. Moving on to my question.
Absolutely. Questions related to the bill are encouraged and welcome. Go ahead.
I appreciate that. So I just want to get back to the amendment. Thank you, Representative Talbot Ross. The amendment, I have a question. I understand the importance of accountability, absolutely. I'm wondering what the impetus was, given that this is not, as you said, a new bill. This is a bill that was heard over the summer. And so I wonder what was the impetus and what is the goal of adding this amendment where the law enforcement officer is released to the Attorney General's office, and what the mechanism is, as you said, of that accountability once the Attorney General does have the data, including the law enforcement officer's name.
Well, thank you for the question, Representative. This bill, as I indicated, and many of you who were on Judiciary last session know, was a bill that was sponsored by Representative Craig Hickman. Representative Hickman was term limited out of the legislature, and so could not bring this bill forward after the legislature abruptly adjourned last year. I brought the bill forward. I believe in the bill. This is the piece of enacting the law, the prohibition against profiling that is necessary in order to track profiling. When I read the last version of the bill, I was in support of it. I brought it forward, except for the piece that keeps the law enforcement officer's name away from the Attorney General's office. I do not understand the rationale for that at all. It doesn't make any sense to me that a law enforcement officer's identification can't be passed along to the Attorney General's office. But I will say that my questioning of that is because I think that the Attorney General's office is the best arbitrator to figure out if there's a pattern and practice of profiling by any individual law enforcement officer or any law enforcement agency. I do not believe that the police can police themselves. And so our current situation says that law enforcement will recognize any patterns and practices of profiling on their own. And I will say, I dare say, with all due respect, that we've had 3 recent incidences that showed that police may not be able to police themselves as well as we would like. And I won't go into any depth around those 3 recent incidents in order to stay focused on this particular bill. But it was my belief that the Attorney General would be the best, most appropriate place in which that information goes. I will remind the representative that by having that information, the Attorney General will not include any personal identifiable information in the reports that come before this committee in criminal justice public safety.
I appreciate that. I do want to speak to the clarification of what do you anticipate the Attorney General doing with the information to provide that accountability beyond simply having the information?
I like to let Representative Libby know that the Attorney General is here and the bill is actually an implementation of the Attorney General's recommendations. But with that, Representative Talbot Ross, go ahead.
Madam Chair, I was going to say the same thing, so thank you.
Thank you. I'll defer to the Attorney General.
Yeah, you'll have an opportunity to re-ask that exact question. Thank you.
Thank you.
Are there any other members of the committee who have questions of the bill sponsor? I see Representative Harnett, go ahead.
Thank you, Madam Chair. And thank you, Representative Talbot Ross, for bringing this bill forward. And it's very good to see you again in the virtual Judiciary Committee room. I want to talk to you about the importance of your amendment. The Attorney General is the chief law enforcement officer of the state of Maine. It's my understanding, having worked there for 27 years. By providing the Attorney General with the identifying information about individual officers, wouldn't you agree that that would allow the Attorney General, whoever he or she is, to not only identify potentially problematic departments, but also individual officers? And by being able to identify those departments and individual officers, he or she may be able to prevent a lot of harm, not only harm to individuals who are stopped unfairly because of perceptions and profiling, but also to protect state and local law enforcement agencies from being exposed to liability in lawsuits for violation of one's civil rights. Wouldn't you agree that that's one of the reasons that the amendment is two of the reasons the amendment is so important?
Well, I thank you, Representative, for the questions. Those are two very excellent reasons for the amendment. And again, I thank you for the question. The answer is yes.
Thank you. Nothing further, Madam Chair.
Members of the committee, I will just ask one more time, are there any final questions for the bill sponsor, or should we move on to the Attorney General? I am not seeing any hands raised, so thank you very much, Representative Talbot Ross, for bringing this bill forward and for all of the information you provided in response to our questions today.
Thank you all very, very much.
And we'll invite you back for the work session and look forward to seeing you then. Attorney General Aaron Fry, would you like to speak to the committee?
Well, good afternoon. Thank you very much. I think there's been a great setup for me, so I appreciate that. My name is Aaron Fry. I serve as Maine's Attorney General. I appreciate the opportunity to speak in support of LD 132 this afternoon. This legislation continues important work that was done during the last legislative session to advance efforts aimed at collecting, retaining, and reporting on data from traffic stops in order to determine the extent of bias-based profiling here in Maine. Now, last March, as it has already been referenced, and as some of you know who served on the committee last session, I delivered to the committee a response that, that really reported on the work of my office in assessing how profiling data was being collected and reported in Maine as of that time. And I noted that the current data collection systems are decentralized, they're not comprehensive, and best we can tell is that there are as many as 13 different systems that law enforcement agencies across the state may use. That was dated information. It went back to 2012, a committee that Representative Harnett and Representative Talbot Ross were on. So we are behind in our understanding as a state as to exactly what our capacity is and is not. So ultimately, I provided some recommendations on how we might improve, or some options on how the state of things might be improved. One of those options, which was option A, recommended that the legislature consider establishing a data and compilation program similar to what has been used with some success in the states of Connecticut and California. LD 132 provides that pathway to establish such a program. Now, while law enforcement agencies in Maine may have adopted policies and procedures prohibiting bias-based profiling, there is limited data of what the scope is of potential profiling in this state. Collecting data, analyzing it, it will have significant value. Not only is it going to provide parties with a better understanding of what is occurring at traffic stops here in Maine, but it's also going to help us better improve the systems that we have already set up to address profiling. That includes, but is not limited to, training that's done through the Criminal Justice Academy, the Human Rights Commission complaint process, and the complaint protocol that we have in my office for bias-based profiling that has been in effect for many years. Now, if done properly, LD 132 would provide confidence that policing in Maine is being done fairly and dispassionately. That's exactly what law enforcement has committed to, and it's what Maine citizens deserve. Finally, I just want to express that my office benefited greatly from perspectives of so many different entities that are impacted by this: law enforcement, legal and civil rights advocacy, other officers here in the state, and folks in state governments and other states. I benefited greatly from that collaboration, and the part of the 132 that encourages this consultation with this range of different groups. It is so important that we make sure that all those voices are heard. So with that, I stand ready to assist the committee in its deliberations on this. Very quickly, just addressing some of those questions that came up that might be helpful and might save some questions. First, with respect to some questions that Representative Moriarty had asked, the intent really is to get at when you have a traffic stop, whether or not there's a citation issued or a violation or a summons issued. So I don't know to what extent the language might need to be cleared up to address that, but the focus really is on the act of that stop and what motivated it. It does not include like a stop and chat. So in Bangor, there's an officer that walks around downtown during the summer. This isn't covering those interactions where the officer chooses to stop somebody to a point that might become some level of seizure. With respect to questions around race, ethnicity, and the appropriateness of law enforcement, them making those perceptions, it's really getting at whether or not there's implicit bias. It is true that race is not on the license. The whole point of collecting this data is to determine whether or not there is some inappropriately based bias that's being used in the way in which Maine citizens are being policed. Anybody can say that it's not happening, that data could show something different. And so there is already, and I'd refer folks to what I submitted to the committee in my response. There's an attachment 1, which is a letter from Major Christopher Groton with the Maine State Police. In that letter, it talks about how there is already some of this information that is being collected, at least at the point of somebody being summoned or issued a violation. On the violation forms, the officer is required or is asked to enter in race at that time. Additionally, there is information that's reported from law enforcement agencies. And again, this is in that attachment 1, this letter, where there's a record management system pertaining only to complaints and suspects. So that's, folks who are being charged with a crime or who are suspected of committing a crime, where age, sex, race, and ethnicity is required to be entered. So I point to that because there is already some level of this activity of officers being asked to enter their perceptions. There's law enforcement officials who will be able to better talk about what that involves on the call. The purpose of this information is really to develop an informed understanding of whether or not there's the existence of improper bias. There's evidence that there may be improper bias. We don't have data to tell us one way or the other to confirm if there's an issue. So the purpose of this collection is to determine whether or not there's an issue that we need to be attentive to, And then B, if there's improvements we can make in the process, the data would support that. With respect to the OAG, the Office of the Attorney General being the agency involved, probably because it's the best office that can operate statewide, that would have some level of independence in assessing the appropriateness or inappropriateness of certain activity. That's not uncommon with the Attorney General's office would be entrusted with that responsibility. And then finally, in terms of the amendment, it's without getting to the language of it, it's my understanding that the purpose of the amendment is to remove any restriction on the dissemination of information that relates to a law enforcement officer, to the activities of a law enforcement officer. I leave it to the analyst, to the sponsor, to the committee to determine whether or not the amendment does that. You know, the section that is being modified here really talks about the report that the Attorney General puts together. And so I don't, if the goal of the amendment is to ensure that information relating to law enforcement officers' activities be freed up for access, I'd have to think some more. I got this yesterday. I had a little bit of time to think about it. Got to think some more about it. But I just offer that maybe I understand the purpose. I just don't know if the amendment gets there. So thank you for letting me go over 3 minutes. I hope that saves some time on what questions might be asked. I hope that this is informative. I will remain available throughout the public hearing. So if there's time after everybody's presented and there's questions for me, I'm happy to take them at that time too.
Thank you very much. And would you also be available for the work session? Because that might be a good format for the committee members to ask additional questions.
Absolutely. And of course, any questions that the committee might have after today that they want to get to me before the work session, I can make sure to have those ready to go for everybody's benefit as well.
Thank you very much. And I see we have a question from Senator Keim. Go ahead, Senator Keim.
Madam Chair, I have a few questions. If you'd like me to wait and speak with Aaron, with Attorney General Fry after other people have asked questions, or is it okay to ask my questions now?
Yeah, why don't you go ahead and ask 2 questions, and then if you need another follow-up. It's just that we're losing witnesses who have waited all day to speak to this bill. And so why don't you go ahead and ask 2, and then maybe we'll move on.
Okay, I'll just make a comment that when it's a train of thought sort of question, it's a lot easier to not be interrupted and just be able to ask the questions. Welcome, AG Fry, nice to see you. So one of my questions is the data that's already being collected, is that obtained from driver's license, or is it from the statement of the person that has, the defendant, or is it an officer's perception currently?
It could be objective or subjective. So the license, at least in Maine, has, age and gender. So some of that is going to be obtainable from the license. If a person summons, and hopefully this will be a cue for the law enforcement to come back to this when they come on. It's my understanding that in terms of populating the race box on a charging instrument, that could either be from law enforcement asking or from their perception. So typically what you're going to see is either W for white, C for Caucasian, BL for black, or B for brown. That may be populated by perception. Ethnicity, which is something that would be populated later on, it is not on a summonsing instrument, but it's part of what's reported in general crime statistics. I'm going to leave that to some law enforcement. I hope they will answer that question directly, because I can't say that I have as much confidence as I should have as to when the determination of ethnicity is made. I will take that question back with me though, and if folks don't answer it, I'm going to text my investigations division chief, so I'll know the answer at the end of all this, so that I can get it to you today.
And then, so the question that I asked the sponsor as well is just what happens when, or what do you foresee happening in regards to filling out this form if a stop is made and there wasn't anything observed prior to the stop, and then obviously they're stopped, you then look in the window and you do see the person at that point. What type of data do you expect to collect, and how are they supposed to fill out that type of information?
Well, so the perception would, to the extent that there's an engagement with the person being stopped, there will be that opportunity to make perceptions. I do understand the question about, well, how do we know whether or not that, there's some bias, some inappropriate bias that played into the original stop. What's going to happen is that we'd actually have data now that connects a number of stops. One stop of somebody who might, be able to be profiled, that's not going to be as telling as a pattern of activity that might contribute to that. So, a one-off, or, where there might be something questionable, I don't think anybody could reasonably argue that that's a problem. If you have 10 stops where there's an overwhelming indication that there may be some implicit bias at play, that will provide some information about whether or not there needs to be some additional training, some additional policies, or in a worst case scenario, whether or not that's a red flag that relates to how policing is being done by a particular officer. That's a long answer to your question. What I'm trying to communicate is just that it isn't going to be so much about that one instant. It's going to be about the data connected with other data points that allows us to understand whether or not it's just an incidental factor, or if there's something more that we should be concerned about. I hope that that's somewhat helpful.
Yeah, somewhat. Thank you.
Do other members of the committee have questions for Attorney General Fry? Representative Babich, go ahead.
Yes, I'll try to be quick. Thank you, Madam Chair. Welcome, Attorney General Fry. My question, Representative Moriarty asked earlier on about traffic violations and traffic stops. I'm sort of revisiting the proposal in the bill under Section 1 in 4752. The A through E regards the information to be collected, but the lead-in paragraph is regarding traffic violations, and that particular phrase, I want to explore a little bit more about stops, because, if I'm a law enforcement officer, in this case, maybe a bad actor who is unaware of his own bias, and I see a person of a different race, and is there a way of me acting in such a way that I wouldn't need to report it? And so I'm asking, for instance, because when I think of traffic violations, I think of moving violations. But if it's a taillight that's out, or less concrete, low tire inflation, or a license plate light, or maybe even just an obscured license plate with dirt, do those fall under the category of traffic violations? Because and those would be legal stops, if I understand that correctly.
Right. So my understanding has always been that the focus was on the seizure, right, the stop, and not whether or not there was some violation that resulted from it. Because in terms of a license plate light being out, or an inspection sticker being a problem, a handicap placard hanging from a rearview mirror, which it's not supposed to do, you can learn a lot about the dispassionate policing versus maybe policing that we should be questionable about. If people are pulled over for a handicap placard meet a certain criteria versus, people who are pulled over for a license plate violation, the focus was not on whether or not a violation was happening. This is about the seizure. And a law enforcement officer, they should not be stopping somebody unless they have articulable suspicion that there's a traffic violation being committed. You can't just stop somebody for no reason. So I think that probably law enforcement would be on the call on this, would validate that. And law enforcement generally should not be just pulling over people to pull them over. So I guess to try to answer your question, this is supposed to be focused on data that's collected when that seizure occurs, based on the articulable suspicion that there's a traffic infraction that's being violated.
Thank you.
I'm not sure what else I could answer that.
Yep, thank you. Thank you, Madam Chair.
Thank you. Representative Libby?
Thank you, Madam Chair. And so my question takes me back to the amendment, as well as I had asked Representative Talbot Ross. And the question, it goes back to the accountability piece. So when you look forward to seeing this bill implemented, how do you see that accountability piece coming into play? When you have this compilation of a year's worth or 2 years worth or 3 of data, what does that accountability look like moving forward?
Yes. So what I would expect is that it would provide some hard, consistent data on what exactly is occurring in terms of how these traffic violations are being policed. And so it's going to confirm that law enforcement, that there's no issue with respect to improper bias in policing, or the data may show that there is some activity that is of concern that needs to be addressed in some way. And that might be through training, through changes in policy at the Maine Criminal Justice Academy, through intervention at the agency level, because this information would also be available for law enforcement chief, right? So if you were a chief over an officer and you see that this data is pointing in a certain direction, it allows for a timely intervention. The reporting here is really focused on getting information to the legislature that can either confirm or suggest improvements on how we make sure that policing is being delivered as we all expect it to be. It's, in terms of the amendment, I don't know that it was contemplated that I'm sorry, let me add that the Attorney General's office, we do have connections with the Maine Criminal Justice Academy. We are an agency that's responsible for overseeing inappropriate activity by public officials, by law enforcement. So in terms of the statewide agency that may be able to provide the most independent assessment, I mean, that's why the AG's office would be involved. What the reporting in what this bill does not seem to contemplate is that next step of some sort of action or discipline or referral by the AG's office. So in terms of like the individual officer who maybe demonstrates that there's an issue, this collection and reporting doesn't appear to contemplate that the AG's office would be taking some action. So in terms of the amendment, I don't, again, I've had the opportunity to think about it for about 24 hours. I can think about it some more. I don't know that I have a reflection that might address the questions that you have about that interrelationship. I'm just offering you what I had understood the purpose of this collection of data in compilation to be.
Thank you. And I do have one more unrelated, but related to this bill question. May I be permitted? Thank you,
yes,
Madam Chair. So the related question is simply, this seems to add another layer of, this is me as my longtime ICU nurse seeing layers of paperwork being added in my prior job. And I am looking at this new database and saying, who is doing the data entry? What does that look like? This new database, where is this responsibility? Where does this responsibility lie? And Has there been any discussion during the summer and now as to fiscal note and what that would look like?
Well, I can offer a partial answer to that. I think there are some folks on the call who might be able to offer a little bit more. So in the report that I had provided to the 129th legislature, it did identify that the experience, particularly in Connecticut, was that, you know, officers roadside would be entering in some of this additional data. Now, as I mentioned, some of this data, you know, like race, for example, is already called for when the summons is being issued. Not clear when ethnicity might be activated for record keeping purposes. In Connecticut, the additional data that would need to be entered, which is consistent with what's being proposed in 132, took about 90 additional seconds on average roadside being plugged into the system. Can't say if that's going to end up being the experience if we put this online here in Maine, but that is information that we found out for a similar proposal that's in effect, that it took about 90 seconds roadside. In terms of the cost, it was recognized that there would probably be some cost, particularly for startup. You need to get systems online, talking with each other and able to pull this information. As I mentioned today, as I mentioned in the report, we have a disparate collection of data as it stands right now. There is some federal money that's available for the startup, which would defray the upfront costs. But there would be some maintenance costs, I suspect. And I think agencies, I appreciate that you have municipal, sheriff, Department of Public Safety, who are probably going to be able to better answer what that's going to mean for both time and cost. For my office, the cost to compile and report on this, it will definitely depend upon what the committee decides upon for what it needs for information. That's the best I can offer for cost. I do expect there will be some amount of fiscal note. Again, some of that would be able to be defrayed by some startup federal money that's available.
Thank you very much.
Representative Moriarty.
Thank you, Madam Chair. Attorney General Fry, I'm looking at section 4754. It appears as though starting in January 3 years from now, you're going to be required to prepare a report based upon the information collected under this new law. So I simply leave you with a suggestion in anticipation of the workshop, knowing that you're going to have that burden of reporting. You may want to consider offering some input on the collection of the data itself and how it will be most useful to you and your office, how it can be collated and communicated most effectively.
And I appreciate that invitation. And yeah, there's really two different functions of the office underneath this. So 4753 proposes the rulemaking process and consultation with the rulemaking process that will help provide some clarity on data collected, how it's collected, training involved, and making sure that that data has some integrity, because that's very important. Right. But I do appreciate that invitation that on the report, it may be helpful. And what I'll do is there actually are some reports from Connecticut and California that I've been reviewing. I will use those since those two states are my guide for the recommendation that I made. I'll be able to talk some more about that at the work session.
Right. Okay.
Thank you. Senator Keim, is your hand raised from a previous question? Okay, thanks. Okay, at this point, I'm looking at members.
I'm sorry, my hand is raised, yes.
Okay, Representative Harnett has not had an opportunity to ask questions, so we're going to let him go, and then we'll come back to you unless it's something that you think could be held for the work session. But let's start with Representative Harnett.
Thank you, Madam Chair, and I will try to be brief. Welcome, Attorney General Fry. How are you today?
I'm well, thank you for having me.
It's good to see you. Two points, two questions. One, given that a report isn't going to be issued for years, and the primary purpose of this is the compilation of data, am I incorrect in assuming that if you saw a trend, or one of your employees saw a trend from a particular department or officer, would you not get in touch with that department or officer to discuss those concerns and those trends?
I would. In terms of what is in the proposal for reporting, it just doesn't include that. But you are accurate in that we don't turn a blind eye to what's coming in that suggests that there's something that needs to be addressed. As I mentioned earlier, there is already the opportunity through both through the Criminal Justice Academy and through the Attorney General's office for reports about profiling to be made. So I would expect that there would be some handholding there. When I was commenting on this earlier, I'm just trying to process what was put forward as the amendment for 4754, what the objective of that is, and what the articulated purposes of the reporting are. But that's a long way of getting to, if we have information that points to an issue, the more information we have about the root cause of that problem, the better off we're going to be able to be at providing a value-added response. So for example, if we don't receive information on individuals who may have been improperly profiled, we're not going to have any witnesses that we're able to pursue, right? If we don't have information on the kind of stop, or the more information we have, the more responsive and adept we can be at turning around that information in a productive way.
And follow up, Madam Chair, quickly.
Yes.
The issue of money was raised. What's this going to cost? And I'm a big believer that budgets are moral documents. And I just want to ask you, don't you think, or do you think that spending money to try to protect people's basic civil rights is a good thing?
This program, this data compilation, it is worth the investment. And as I indicated, not only is it worth the investment, but I am confident that we could find ways to make sure that the overall burden on the general fund and on different agencies that might have to do this is going to be worth it, because ultimately it's going to confirm exactly the state of how policing is being done. It's going to ensure that the relationship between law enforcement and citizens is exactly as everybody is committed to and expects. And that there is a value to that. So that's my way of saying, yes, I do believe that this is something that is priority to spend resources on.
Thank you, Attorney General Frye, and thank you, Madam Chair.
Thank you. Excuse me, Senator Keim, you may go ahead.
Thank you, Madam Chair. Attorney Frye, the other question I had, which actually Representative Harnett touched on just a bit, was he asked if you saw something concerning as a pattern of behavior with an officer or department, would you follow up prior to the report? My question is, so we've now included, this change here includes that the name of the officer be included. And so does that concern you at all, that if we're asking officers to list their observations and then attach their names to this, that then we might not be getting accurate data from them?
So and this is why the spending time with it is going to have some value. The way I had understood the way the information was collected and retained was that the Attorney General's office, the appropriate agency, we were going to have access to that data all along, like all of it all along. It was only on what was going to be reported publicly that section 4754 was really focused on. So I don't know how direct that is to answer, except to say that I had expected that there would be, that the information that's collected was going to be available to the Attorney General's office, presumably would be available to the agency that's entering their data, right? So that if the Oxford County Sheriff's Department was entering data into the system, that the sheriff would be able to at least pull down that data to be able to provide some oversight for what's going on to that sheriff's team. I had always expected the availability of that. And of course, we're not going to sit on a violation or a concern, right? I mean, a law can be benefited from dialogue, not waiting for the annual report, right? So that's what I'd always expected. I don't know how this amendment changes that ability. And so because I hear what's being put forward, it hasn't connected for me yet if this is doing what it is that's proposed to be done.
Understanding that Attorney General Fry will be present for our work session, and actually this is an issue that I think we should really work on between now and then. Are there any other questions from members of the committee for Attorney General Fry? Not seeing any hands raised. Thank you very much for being here today, Attorney General. And you had indicated earlier that you would be willing to stick around for the hearing in case we wanted to circle back with you. And if you're still willing, we'd appreciate that.
Yes, absolutely. I'll be right here. Thanks very much.
Okay. And then turning to the list of people and those who are still with us, the next witness is Chief Jared Mills from the Maine Chief of Police Association. You have the floor, Chief Mills.
Thank you, Senator Carney, Representative Harnett, and esteemed members of the Joint Standing Committee on Judiciary. My name is Jared Mills. I'm the police chief here in the city of Augusta and the first vice president of the Maine Chiefs of Police Association. I'm here today to provide testimony in qualified support of LD 132 on behalf of the Maine Chiefs of Police. We support the collection of data which could determine with proper analysis whether there is improper or illegal profiling being conducted by any law enforcement officer in the state of Maine. LD 132 sets up a framework for doing so. At the same time, it leaves a number of details to be worked out, and it raises some questions that need to be answered. Profiling is defined as the act of suspecting or targeting a person on the basis of observed characters or behavior. For purposes of this bill, it's the characteristics of race, color, ethnicity, gender, and age. In the discussion about profiling in the world of law enforcement, we often hear the word perceptions in place of the term observed. Perceptions are everything, and perceptions are not bad. In fact, they are critical to what we do. If we perceive or observe illegal behavior, we must act. But when a law enforcement officer focuses on what they perceive as a person's characteristics in deciding whether to take action, such as a traffic stop, there is a problem. As the senior law enforcement officers of our respective agencies, we want to know about these problems so we can act. We also need to think about how capturing these perceptions is going to work out in practice. Here are some of the questions raised as we contemplate how to do this. Will officers describe each characteristic, or will they be provided with a checklist to choose from? And will the checklist include the option of unknown? How does one determine another's ethnicity? Will officers unsure of a driver's ethnicity or the characteristics decide to ask the driver for this information? If so, will the driver be offended? Will their Fourth Amendment rights possibly be violated for detaining them beyond the scope of the stop? Will officers who want to avoid being accused of bias select a characteristic that may not raise the same question that selecting another characteristic might? One way of avoiding the need to wrestle with any of these questions would be to ask drivers to provide this information when they apply for a driver's license. Whether that information would actually appear on the license or whether it would reside in the database to be available to the officer during a traffic stop or other activity is a matter of cost. This approach would admittedly not be one based on the officer's perceptions of a driver's characteristics. However, we believe it would nonetheless capture useful data for analysis while avoiding the pitfalls we indicated above. I am sure there are other questions we may not have thought of that need to be considered. Please note that the Maine Chiefs of Police Association stands ready to participate in a working group that would work on providing answers to these questions if you decide to move this bill forward. Thank you, and I'll entertain any questions that you might have.
Thank you, Chief Mills. Do any members of the committee have questions for Chief Mills? Representative Babbage, go ahead.
Thank you for, while I'm looking for my raised hand function, I appreciate it. Thank you. Chief Mills, just very quickly, would you clarify for me the requirements? I know things have evolved over the last few decades, especially, but what are the current requirements that justify a stop?
Yeah, that was a great question that came up earlier, Representative. Thank you. So we operate on what's called articulable suspicion. It's a little bit less than probable cause, but basically it can be, as discussed before, a taillight out or even weaving within a lane. There's some national traffic, some NHTSA standards that are indicators of impaired driving, somebody weaving within a lane for a certain period of time. Things of that nature. So that's the standard we operate is articulable suspicion, but there has to be a reason. It can't just be something we decide out of thin air.
And if I may, Madam Chair, if this law should pass as written, do you see a traffic violation encompassing anything like that would encompass a stop? That would kick in the need to collect data.
As this bill is presented, I would say that this would qualify as collecting data, this type of stuff.
Thank you very much, Representative Babbage. Senator Keim, did you have a question?
Yes, thank you, Madam Chair. Thank you for being here, Chief Mills. I think in your testimony, you brought up some of the same questions I had, but one question based on what Representative Babbage just asked, and AG Fry mentioned as well, that you can't stop a person for no reason. But I've had the experience that you can. So maybe just as we think about through this bill and the practical outcomes of it, you could help me understand this. I think a couple of times I've been pulled over just because I think officers at some point are allowed to just do random times where they just pull people over. I don't know. Like they're I'll give you the example and you can help me understand it. One time it was like 11 p.m. at night or something, and they were just it was in Lewiston, and they were just kind of pulling everybody off to the side. And I don't know why or what they were checking for. But I wasn't pulled over for anything for myself. I was just part of some bigger net. So I think there are broader laws out there that allow something like that to happen. So maybe you could just speak to that and how that might play out with this particular bill here.
That is a great question, Senator, and I'm glad you asked because I forgot about exactly what you're talking about. And that would be the checkpoints that are run, driving under the influence checkpoints that we have. And you're absolutely correct. In those checkpoints, they don't happen as often as traffic stops, but they certainly do happen here in the state of Maine. So you would be stopped with a group of people to be checked for a impairment, if you will. And I would anticipate with these types of checkpoints, based upon the way the bill is presented, and quite in my own opinion, that data collection is important. This would fall under that as well on these contacts, if you will. But certainly, if it wasn't anything that, if that was stricken from the bill, we would that wouldn't have any. We wouldn't have angst with that as the Chiefs of Police Association.
Thank you.
Thank you for the question. Representative Evangelos, do you have a question?
Yes, thank you, Madam Chair. Chief Mills, thanks for your input. You previously stated in your testimony that you need some kind of probable cause or articulated suspicion to pull somebody over, but now you've just contradicted yourself. You're saying that these roadblocks that are put up aren't based on any reasonable grounds. So I'd like to get clarification on that.
Thank you, Representative Evangelos. That's absolutely for giving me the chance to do that. And I can only plead that I had forgotten about those types. I'm so focused on traffic stops, as we say that. But in Maine, there are checkpoints, these types of safety checkpoints. And there are also checkpoints if, say that, we were looking for a wanted suspect. If there was a homicide that happened, those occur as well when we're looking to pass out information and that type of thing. So there are those occurrences, and maybe there are others I'm forgetting, but they pass case law. They're completely legal. They have been tested in court, and as long as they're set up appropriately and you're not picking and choosing who you're stopping, you're stopping the everybody in that group or the group itself, and there's no, you're not discriminating or targeting particular groups. Those are absolutely legal in the state of Maine as we speak right now.
Chief Mills, I'm sorry to interrupt, but is anybody else having a hard time with the audio?
I can't hear him either.
Okay. Chief Mills, there may be something covering your microphone, or you had come across really clearly initially. And if you could, I think we heard most of what you said, but if you can just give us a short recap, that would be helpful, because we did have a hard time hearing you.
Sure. Can you hear me now? Okay.
Much better.
Okay. Sorry about that. Yeah. So basically, there are certain instances that I had forgotten, and I do apologize. I was so focused on traffic stops, like these safety checkpoints with impaired driving. I did think of another one as we were speaking. At times, when we've had homicides in the city, if it's a particular area, we've handed out information looking for witnesses and that type of thing. So there are certain checkpoints like that have passed the muster of case law, have been litigated, if you will, to be legal here in the state of Maine. So those are other examples, and I do apologize for forgetting. I was so focused on traffic stops.
Thank you, and thanks for restating your answer.
They had a follow-up.
Are you concluded, or do you have another question, Representative Evangelos?
I had a follow-up question.
Go ahead.
Chief, these stops are being challenged across the country regarding their constitutionality, but one of the areas is that when they pull over an inordinate amount of people, people are being detained for a period of time in excess of your right to detain us. Do you have any response to that?
Only that obviously we work under the parameters. We actually have a policy, a model policy that we operate under within our agency, and I can only really speak at this point for my particular agency. But yes, we have no interest in detaining anybody any longer than is reasonably required under the law. So if that were to happen to change through litigation, obviously we'd follow that accordingly as well.
Thank you. Senator Keim, is your hand still up or up again?
Up again, Madam Chair.
Okay, go ahead with one question, please.
I only want to make a comment for the work session. I think it would be helpful to have the language around these sort of extra stops that happen that are without cause. And, I don't know that they're only for OUI, but I just think we should have all that information because it does play into this bill.
Great point. We'll do that. Thank you. Representative Babbage, did you have a question?
Yes, a very brief one. I think that the Chief might be able to answer quickly. Thank you, Madam Chair. Chief Mills, the checkpoint issue that you brought up, I don't think in general applies to what we're looking for here. We're looking for decision making on the part of an officer in making a stop. So is there a checkpoint situation in which officers have random stops that include choice of whom. In other words, even if it's every third person, that excuse me, this is my voice, not your reception. Excuse me. But if it's every third stop, or if it's everybody that's being pulled over, then the choice is being taken away. But do you ever have a situation where you'll stop every 5 to 10th person and there's actually decision making on the part of the officer as part of a checkpoint operation? Thank you.
That's a great point, Representative. And I can only speak from experience on this point because I've worked these before in the days of being a real police officer. I'm joking. So basically, you have to take away what we're talking about. There can't be that biased, that selection of I'm going to stop this one, but not that one. It has to be in the way the policy is written, consistent. So it's all at times I can tell you, and it's written in the policy. If things were to get backed up, and we were obstructing traffic, and that became an issue, you have to let everybody go and start over again. So it takes the ability of being biased out of it, or at least that's the way the policy is written. So if there was any bias, that would not be permissible.
Thank you very much, Chief Mills. Are there other questions that relate directly to LD 132? Representative Evangelos?
Thank you, Madam Chair. I just wanted to follow up with the chief, if I may, for a second. Brief question.
Yes, one brief question. Go ahead.
Chief, I know down in my area, when they had done these checks before, they included the DEA and dogs and stuff. And I think that could really lead to some serious profiling. Have you experienced the Drug Enforcement Administration being involved in these so-called checks with no probable cause?
Personally, I have not been involved with any of those. I'm not aware of any others, but not saying that doesn't happen.
Is everybody all set with questions for Chief Mills? I'm not seeing any raised hands. So Chief Mills, thank you very much for presenting today at the hearing.
Thank you very much, Senator.
The next person on the list who's still available is Jan Collins. Jan, could you please both unmute and also turn on your video?
Greetings, Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Jan Collins. I am Assistant Director of Maine Prisoner Advocacy Coalition. I'm here to support LD 132, an act to implement the Attorney General's recommendations on data collection in order to eliminate profiling in Maine. MPAC's purpose is to reduce Maine's use of incarceration by creating a criminal justice system that is ethical, humane, and restorative in nature. I have submitted written testimony, and I'm going to divert from that just a bit. I want to note that there is plenty of reasons to go forward with this profiling data collection. Stop data collection to see if there's profiling.
Excuse me.
That data is based on.
I'm
Yes?
sorry to interrupt you, but
Yes.
your connection may not be strong. And so if you did want to turn off your video in the hope that it would make the audio stronger, that's fine with us as a committee.
Thank you. I'd be glad to do that. Is this better?
You're very clear.
Thank you. So I have written testimony that I've submitted, and I'm diverting from it a little bit. And the reason why I'm diverting from it is to point out that there is supporting evidence that would give us plenty of reason to do a study to check for profiling. We know that despite the fact that both people of color and people who are white use drugs in the same proportions, we have a 7 times greater number of people who are arrested for drug use in the United States. In Maine, we've had several studies about juvenile disproportionate minority contact, 2010, 2011, 2012, and 2015, that show clearly a disproportionate minority contact. In addition, we have plenty of evidence that shows that the number of adults in the adult system also have a disproportionate contact with the criminal justice system. Traffic stops would seem to be a simple, effortless, and necessary way to begin this analysis. Data is essential to defining, addressing, and eliminating profiling in Maine. I would ask you to vote ought to pass for LD 132, an act to implement the Attorney General's recommendations on data collection in order to eliminate profiling in Maine. And I will thank you so much for the opportunity to speak to you today. And if there are any questions, I am happy to answer them.
Thank you very much, Ms. Collins, and we will also do have your written testimony. Are there questions from the committee for Ms. Collins? I am not seeing any questions. Let me just double check. No, I think that you're all set. Thank you for appearing before the committee today to testify.
Thank you. I appreciate it.
The next person who has requested to speak to us is Megan Maloney. Megan, you may proceed.
Thank you. Senator Carney, Representative Harnett, and honorable members of the Judiciary Committee. My name is Megan Maloney. I'm the District Attorney for Kennebec and Somerset County, and I am the president of the Maine Prosecutors Association. I'm here today to speak on behalf of the association in support of LD 132. From September to December of 2020, the Maine Prosecutors Association underwent an extensive 6-part implicit bias training. The training confirmed our understanding that all of us carry implicit and subconscious biases that we need to recognize in order that they don't control our decisions. Beyond training to recognize and acknowledge such biases, we need to slow down, take a second look, and even have someone else take a second look to be sure that we're acting on facts and not biases. The best way to have someone else take a look at law enforcement is to collect the data. Without data, we can only guess. With data, we can develop policies and procedures to address any concerns that the data brings to light. Collecting the data will help law enforcement take that second look and perhaps identify and solve problems. Law enforcement has a duty to treat all people equally under the law. To be certain that we are treating people equally, let's collect and share information. It can only lead to greater transparency and equality. We urge you to vote in favor of LD 132. I'd be happy to answer any questions.
Thank you very much. Are there any questions for Ms. Maloney? I'm scanning the screen and I don't see any. Thank you very much for presenting today.
Thank you. And I also owe you tribute. So I will remember.
We'll take you up on that. Thank you.
Thank you.
The next person who signed up to testify in support of this legislation is Megan Sway from the ACLU Maine. Ms. Sway, you may proceed.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the committee. My name is Megan Sway, and I am Policy Counsel at the ACLU of Maine. I'm sorry that I am backlit. I was in good light this morning, but it's gotten a little bright, so I'm trying to stand in the way and not blind you all. I'm here in support of LD 132 because, as those of you who have been on this committee for a while have heard from former Chief Justice Softly, we need data collection because we manage what we measure. And if we're to understand and address the role that racial and other identity profiling plays in law enforcement decision-making, we have to get basic information about what police are doing and with whom. Data helps us move from anecdote to evidence-based solutions. And as Attorney General Fry gave testimony about, there are many states that have implemented data collection laws, but two in particular are very robust, good models, and that's Connecticut and California. Those two states went through years of trying to figure this out, and I believe that a lot of their experiences can inform this process here and can make the process of doing this shorter and alleviate, hopefully, some concerns over some of the questions you've had today. I attach to my testimony that I submitted a letter that the ACLU of Maine submitted to Attorney General Fry that has more details about that. But I'm also happy to provide any other information that I can about California or Connecticut. I also just wanted to briefly touch on the proposed amendment to take out the last paragraph of the bill as written. And we support that because police officers' identity are already protected under personnel laws. Both municipal and state employees, their personnel records are protected if the information contains records that may result in disciplinary action. And so under our understanding, that last paragraph is not necessary because the police are already protected. And because racial profiling is unconstitutional, we think it's bad governance from a public policy perspective to keep from the public information related to government officials who act under the color of law. This is in part why we require police officers to wear badge numbers when they're out in public. It's so we can identify them and their actions. They're public servants, as you are, and while that doesn't mean that they should be abused, neither should they be treated differently from other public servants. So we would support removing that last paragraph. Racial profiling violates equal protection and infringes on Fourth Amendment rights that guarantee that all people be free from unreasonable searches and seizures. In order to ensure that this does not happen, the state must collect data and make that data public. Thank you.
Your timing was perfect. I was just about to show you that you were getting toward the end. Thank you very much for providing the information today, Ms. Sway. And I see that we have a couple of questions. Representative Babbage, do you want to proceed?
Thank you very much, Madam Chair. Very quick one. Hello, Ms. Sway. Good to see you. Could you just clarify the source for me again? You said that the paragraph was unnecessary because records are protected that would reflect actions that could result in disciplinary action. Is that in statute?
Yes, both statute.
I was wondering, my choices were a statute, policy, or contract language. It's not a collective bargaining issue or something like that. It's in statute.
You know, I don't know if they're I'm sure there are collective bargaining issues, but under state statute, Title 30A, Section 2702, and Title 5, Section 7070, which I cite in my testimony. There are two cases on point. The Lewiston Sun Journal versus the City of Lewiston, and I can't remember which paper sued the City of South Portland, but those are two cases that sort of interpret these laws and might help give you guidance about what is already protected.
Thank you very much.
Are there questions from other members of the committee for Ms. Sway? Just scanning, and I do not see any. Representative Harnett, did you have a question? No. Okay, great.
I did not, sorry.
That's fine. All right, thank you very much, Ms. Sway, and thank you for your written testimony as well. The next witness we have signed up to testify in support of LD 132 is Brian Scott, and Major Brian Scott is here today. You may proceed.
Thank you, Madam Chair. State Police is actually neither for nor against. Would you like me to hold off on my testimony or go ahead now?
Hold off for just a minute and let me see if there's anybody in support. So just a moment. With that additional piece of information, I would ask if there is any participant in the electronic meeting who intends to testify in support of LD 132. If so, please raise your actual hand or raise your virtual hand using the raise hand function. Okay, I am not seeing anyone indicating interest in testifying in support of. And so at this point, we will move on to those who are here in the electronic meeting to testify in opposition to LD 132. If you are here to testify in opposition to 132, please raise your virtual hand or your actual hand. Okay, and I'm not seeing anybody here to testify in opposition to the legislation. So now we'll move on to those who have expressed an interest in testifying neither for nor against. And in that regard, we will start with Major Brian Scott. You may proceed.
Good afternoon, and thank you. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on Judiciary. My name is Major Brian Scott. I'm here today to testify on behalf of the Department of Public Safety and the Maine State Police, neither for nor against LD 132. The bill, amongst other things, would require law enforcement to collect the race, color, ethnicity, gender, and age of each person stopped for a traffic violation in Maine, and to report that data to the Office of the Attorney General. While we support the overall concept of the information collection and being able to later mine that data to determine if there are any areas of concern regarding profiling, we do have some apprehensiveness and some questions with the bill as written. Accurate data resulting in greater transparency of policing in Maine is certainly welcome, but as currently drafted, some of the data might not be very reliable. My understanding is that the committees want data on traffic stops. That would be all stops is our opinion, but section 4752 of the bill uses the phrase traffic violation several times. So we would ask, what about the stops for suspicious activity, burglary suspects, criminal activity? Would those be included as well? The bill would also require the officer to use their observation and perception to determine race, color, ethnicity, gender, and age. Officers do not have the ability to accurately determine a person's ethnicity and race by looking at them, and that data is not currently captured on a Maine driver's license. Using the perception and observation of the officer will result in inaccurate data, as the officers will have to guess in an effort to try to capture the required information. The bill wants data on all persons stopped for traffic violations. So I question, does this also mean collecting data on passengers since they too are stopped? And if the answer is yes, that would be problematic. We can discuss that later. But also sometimes a stop is for a passenger that's not wearing a seatbelt or some other violation. Would we only report the data on the person who committed the violation or suspected of committing the violation, or on the driver as well? We would ask, does this proposed statute also mean that commercial motor vehicles that are stopped in truck safety checkpoints should be included in the data collection effort? This would result in an additional 100,000 plus documented stops per year that may slant the statistics, since these stops are regulatory in nature and do not require reasonable articulable suspicion. Several agencies, including the Maine State Police, do not currently have a database to capture the information contemplated in this bill, and there is no statewide centralized repository for this data. However, this could be resolved with funding and mandates. This bill would authorize the Attorney General's Office routine technical rulemaking authority regarding the recording, retention, and reporting of the required information. However, the most likely result of any rules will require a database with some built-in logic and some query capabilities with a significant cost to law enforcement agencies in the state. If you were to consider that just the Maine State Police stops about 75,000 vehicles annually, not including commercial vehicles, it should be kind of easy to see that we would need an electronic database for this purpose. When LD 1475 was presented, that was during the 129th, that was an act to eliminate profiling in Maine. The Department of Public Safety began exploring ways that this data collection could be done on a statewide basis in a consistent, manageable manner. These efforts have resulted in a proposal for your consideration, but it is still conceptual and required some work. Currently, the Bureau of Highway Safety, along with its vendor, maintain a relatively new system called eCitation. This is a tool that allows officers to capture data from suspected violators and issue a summons electronically and print out a paper copy for the defendant. Very few agencies currently use the system for a myriad of barriers. Many of those reasons are the cost associated with the hardware and credentialing to ensure a secure connection with the system and prevent unauthorized access to sensitive information. If some of those barriers were removed, we might be able to get statewide adoption of eCitation. If that were to occur, then all law enforcement could use this same system if they chose to participate. Now, this current system can only be used for the issuance of a summons and does not capture the data that this bill seeks to acquire. However, if we added a warning module and additional information fields, that might make that possible. Of course, there'd be a cost associated with that, and we're happy to work up some costs. If this route were to be taken, there would also be staff time and other costs associated with that type of a project that we would have to work out. On behalf of the Department of Public Safety and the Maine State Police, I thank you for your time, and I'd be happy to try and answer any of the questions that you have. In my written testimony, I did provide a little bit more information, but had to cram 5 minutes into 3. So I was very succinct, and please feel free to ask any questions. If you have them, I'll do my best to answer those.
Thank you very much, and thank you for providing your written testimony as well. That will be helpful to us. Looking at two members of the committee for questions, and I see that Representative Babbage has a question, as does Representative Reckitt. Representative Babbage, go ahead, and then Representative Reckitt.
Thank you very much, Madam Chair. Thank you, Major Scott, for some excellent testimony to try to help us here. Given reasonable articulated suspicion, can you help me with, I don't know if you were listening earlier when I talked about tail light, low inflated tires, obscured license plate. Would that fall under that category?
Representative Babbage, the answer is yes. So any of those traffic violations, those two words together do have a very specific meaning in Title 29A in the Maine Motor Vehicle Codes. And so a traffic violation would be a safety defect. Any of those violations that an officer decided to make the stop, my opinion, based on the interpretation of this, the way that it's written, would require the data collection to kick in, regardless if the officer issued a summons or a warning. It's still a traffic stop for a violation, even if it does not result in a violation summons and complaint being issued.
Thank you. And can you tell me what you mean by suspicious activity? What kind of stops might happen as a result of that?
Sure. So there are certainly times, and Chief Mills had mentioned this earlier, when he talked about reasons that you might stop a vehicle for a suspicion of criminal activity, like if a homicide or something significant had occurred. But there are also other times where an officer may observe some type of suspicious activity, such as a high crime area in a location maybe where there's been a lot of commercial burglaries at certain times of day in the middle of the night, and an officer on routine patrol happens to notice a vehicle exiting a parking lot of a closed business with no headlights on and operating out into traffic and then turning their headlights on. There might be some suspicion that immediately comes to the officer's mind, but it might not quite rise to the level of a traffic violation. It could be a suspicion of criminal activity. So the reasonable articulable suspicion standard, you'd need to build just a little bit more in order to say that there was a violation of law. And that might be when they turned their headlights on, they had a tail light out. And now you've got that reasonable articulable suspicion. So you could arguably have that fall into that category. But other areas, I think, would be when you have reasonable articulable suspicion to believe that a crime has occurred, and by an operator or an occupant in a motor vehicle, and you're stopping them through an investigatory detention to further your investigation. So that could be any type of crime. That might be a person who has, let's say, fled a complaint of a domestic situation with a description of the vehicle and the operator and a registration plate. They may be suspected of criminal activity, and we would stop that vehicle as a result of it to do an investigatory detention and further our investigation. However, there might not be any traffic violation associated with that. It's because we believe there's a criminal predicate that led us to that traffic stop. So it's not a traffic violation, just a traffic stop.
Thank you for that. Appreciate it. Thank you, Madam Chair.
Thank you. Representative Reckitt?
Couple of quick things. I'm intrigued by the eCitation program or process that you were articulating. How long has that been in use in the state?
So I don't have an exact date. What I can tell you that eCitation, I believe its rollout as a pilot project started right around 2018 or 19. It started on the main turnpike and a few select law enforcement agencies. It's grown since that time, but I believe we're only around a dozen agencies in the state of Maine that currently participate with eCitation. And I believe there are several others that are interested in the process of trying to get signed up with the state for eCitation access.
One other quick question. How many, and I should know the answer to this, but I don't off the top of my head, how many officers are there in the, that are actually out on patrol kind of officers in the Maine State Police?
So the Maine State Police has a complement of about 314 officers, but that is from road troopers all the way up through detectives, corporals, sergeants, lieutenants, and up to the colonel himself. I would say we have around 150 statewide that probably would fall into a patrol category, as I believe that you had asked the question. And statewide, there's a little bit over 3,000 police officers in the state of Maine, if you include full and part-time officers.
So in my head, that, because you mentioned that there were 75,000 stops a year, my head's going, how many stops is an officer making every day? Or every year. And it seems to me that if there are 150 officers, then each one is making either 500 or 50 stops a year. I'm not sure which, but in any case, when my mathematical brain kicks back in, I'll do the division, but it seems like an awful lot of stops. Is that accurate? That there's an awful lot of stops?
Representative Reckett, that is a very fair question. And the answer is yes, it is accurate. Now, with statewide law enforcement coverage, we also have the Maine Turnpike Troop. So we have a full-time troop who is dedicated entirely to traffic patrol on the Maine Turnpike. And for an officer to stop 7 or 8 vehicles in an 8-hour shift, I think is very reasonable and would put us well over that category if all of our officers were in that same production rate. But we've got others in field troops that are very busy responding from call to call to call who just don't have an opportunity to do a lot of traffic work. So those numbers are averaged out throughout the state. And that includes our overtime efforts. Some of those are funded through highway safety with details towards occupant protection, OUI, speed enforcement, distracted driving, and those things. So that's all of our numbers combined for the year.
Thank you. I just have to say, I wish you well with traffic stops on the Turnpike. And I wish there were more of them on 295 because I'm one of the 3 people in the state that drives the speed limit. And honest to God, I get dirty looks, horns, all manner of stuff, but I'll be darned if I'm going to do otherwise. So it's a good job you guys do. Thank you.
Thank you, ma'am.
Representative Libby, you may ask your question.
Madam Chair, I'm interested in the mechanics of the database. And it sounds like you've done some research there as to how that would function. And I'm looking at this number, it's about 75,000 per year. If we have a number, I believe that it was Representative Talbot Ross that mentioned 90 seconds or so for data entry, given that some of the data entry is information that we're already gathering, that you're already gathering. So I guess I just wonder, is this, how smooth would this be? Is this data entry that would be kind of auto-populated from systems that you already have? Is it completely separate? How would that function? And if you have any information regarding that, because the math to me seems pretty significant. 90 seconds doesn't sound like a lot of time, but when you multiply that by 75,000, that's a pretty substantial amount of time. So I just wonder if you could speak to that a little bit.
Sure, and thank you for that question, Representative Libby. So the concept of e-citation, the way that it's currently used is that an officer takes the information generally from a driver's license or something that the officer might have inquired. If somebody doesn't produce a license, they're going to ask for a name, date of birth, and often an address, something to help to identify the person. Once you run that information through a database that most officers have in their cruisers, but not all, but most would have access to the database, that database will provide information. The goal would be to have that information automated, populated, but it's only going to populate the fields that are currently captured on a Maine driver's license. So it really depends. There's so many questions that I have if we were to actually try to implement the system. Just to talk about e-citation in its current form is going to be different. E-citation with a warning module with added fields. If the committee's pleasure is that we add those fields, then we're not going to be able to populate certain pieces of information if they don't come from a computer generated check, where we could, with technology, have that information again automatically apply. So we would be talking about data entry on the side of the road. I would hope that it would be relatively brief. I also am concerned about asking folks certain questions that they're not required under current statute to provide. The law only requires that you produce your driver's license when you get stopped. If you don't, then there are certain pieces of information that we can currently legally ask and demand. So you can ask questions, but to legally demand it, it's actually very brief. And what it says is it's got to be the person's correct name, address, or date of birth. We've got experience with that, so I could probably give you a guess of what it would take by way of how long on the side of the road, but it depends on the number of questions that we end up having to answer and where we're going to glean that information. So I think we need a little guidance on what the committee would like eventually, and then we could work out the nuances and give a better idea. I'm concerned with 60 or 90 seconds delaying a stop. If it's part of our regular stop, probably not much of an issue, but as Chief Mills had mentioned earlier, there's a United States Supreme Court case from 2015. It's Rodriguez versus the United States, and it basically said, although it wasn't germane to this type of stop, it was related to a drug sniff for a canine, but it is germane to all stops. It says you can't measurably extend the scope of the stop outside of the reason for the stop unless you're able to articulate that there is some other violation of law or criminal activity afoot. So those things have to be worked out. And I'm sorry for the long response to your answer, but it is a little bit complicated and really not a yes or no in my mind until some of our questions get answered on what the direction would be. What's the task from the committee? And I would certainly be willing to try to narrow that down by way of a time frame and maybe how the system would work and be able to provide you with some particulars instead of concepts.
Thank you. No, you answered my question very completely. Thank you very much.
You're welcome, Representative.
Thank you, Major Scott. We're going to take just a little pause so that our committee member, David Hagan, may introduce himself.
Thank you, Madam Chair. I am David Hagan. I represent House District 101, Hamden and Newburgh. Once again, thank you.
Do any members of the committee have additional questions for Major Scott? Representative Babbage, go ahead.
Thank you, Madam Chair. Major Scott, could not some of the information we're asking actually take place by being recorded in the cruiser after the stop?
So Representative Babbage, if I understand your question, I believe that is where this data gathering would take place, would be roadside, and then data entry would be done in the cruiser on a laptop. It's not available to all officers right now. Not all are connected to that system, so it would take some time to get there. But that is, if I said something differently or left you with a different impression, I apologize. This would happen on the side of the road.
I guess what I'm asking is, I think if too much time elapses, the accuracy or recall might not be the same. But I'm wondering how much of an interrogation, that's the wrong word, but how much has to be done beside the car of the person stopped versus doing the officer's job, returning to his cruiser, and then attending to what we're requiring in this bill. Is
that makes sense, Representative. And I think I might go back to what was said earlier. I believe it was Chief Mills. that if over time, and it doesn't fall into my purview, so I can't volunteer to do the work, but if the Secretary of State's office collected certain pieces of data when they were doing the credentialing for driver's licenses, that information may become available to us electronic, and it would preclude us from having to make inquiries on the side of the road that might potentially offend somebody and cause the very harm that you're trying to protect by collecting the data. So that might be the best way to do it, but I realize that driver's licenses are good for 6 years. So even if that statute were to change immediately, it would probably take 6 years in order for all of that data to be consistent, and it would still leave us with some holes in the data to deal with right now.
Thank you. And I am not seeing any additional questions from members of the committee with a quick scan. Senator Keim, go ahead.
Thank you, Madam Chair. Yes, I just listening to you and thinking this through. I think help correct me if I'm wrong, but I think the purpose of the bill is that we ascertain whether officers prior to making a stop made an observation or some perception about a person that led them to make the stop in the first place. And yet, I mean, you're clearly saying here that the officers, if the officers don't really have the ability to accurately determine a person's ethnicity and race by looking at them. And so the fix you're suggesting is that if this information be captured on a driver's license?
So Senator Keim, thank you for that question. I think it's a good one and worthy of a point of clarification. So yes, the answer is it is often unknown to the officer what someone's race, age, gender, identity, or other characteristics are prior to a stop, especially if you're behind a vehicle and don't have an opportunity to observe the driver clearly. Sometimes you're looking through a back seat or passengers or tinted windows, or it's at night and you can't tell that information. But also you're traveling at 60 miles an hour down the road and have someone go by you 60 in the opposite direction for 120 mile an hour closing speed. You might easily tell on your radar that they're doing 60 and a 35 and you've made a determination to stop that vehicle. But at that moment that you're passing the other vehicle, oftentimes, and I guess I would challenge anyone to just try that on your way home and think about that. Sometimes you just got all you can do to identify the vehicle and make a turn on it in a safe location, let alone trying to identify any of these characteristics of the person that's operating the vehicle. So oftentimes my feeling is that an officer will not know what the certain characteristics of an operator are. Sometimes you may, but there's other times that you're not going to. And even once you stop a vehicle, I believe officers would have to guess, quite honestly, if they're going to make a determination as to race and ethnicity. As I look to race, I was looking online to see what the categories were. And there are about 30 that are listed as subcategories. I was just looking at for instance, if you were going to have an Asian as a race, it says those would be folks potentially from Cambodia, China, India, Japan, Korea, Malaysia, Pakistan, Philippines, Thailand, and Vietnam. And I just don't know how an officer is going to know what their ethnicity is or what their race is. It's not on their driver's license because it's not currently collected. And if we don't ask, we're being asked in this bill to guess with the best of intentions. I got to be honest, we're not that good. At least I'm not. I cannot identify driver's race or their ethnicity by looking at them.
Yes, thank you. That was a question I had earlier as well. I appreciate that. Thank you.
You're welcome, Senator.
Members of the committee, does anybody have a final question? Representative Babbage, I know you've asked a number of questions. Why don't you go ahead and proceed with your
final question? Thank you, Madam Chair. Thanks for that, Major Scott. I don't think accuracy to a person's ethnicity and even race is what is being asked in this bill. I think what we're trying to find out is, you know, who is stopped in the perception of the officer. And the officer's accuracy is almost immaterial. It's the perception of the officer at the time. And since there's no personal retribution that will happen as a result of the officer's actions, it's protected, then the data is something for us to gather in the perception of our law enforcement community. We'll be able to assume how many people are stopped, how many people are let go, blah, 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 you know, and get data that we can determine for ourselves. Is it helpful at all? I mean, there'll be multiple reasons why something may happen. So we're trying to.
Did you have a
Yeah, my
Representative,
question,
did you have a question?
I think he's operating on an assumption that the data has to be accurate, and I'm asking him, is that really necessary? I don't think an interrogation is asked for in the bill of the driver. It is merely a perception of law enforcement from the stop. You know, so I mean, I'd like Major Scott's consideration of that, or is that not how he sees it?
Thank you, Representative Badgett. That's a fair question. The way that I do see it is I've heard what you've asked, and I also heard what the sponsor of the bill had said, that this is about perceptions. Perceptions are reality in many respects, and we're trying to determine whether or not we have a problem with profiling in Maine. And I think the way to do that is with accurate data. And so I understand what you're saying is you would list it based on the perception, but the underlying cause or reason for asking the question is determine whether or not the person was stopped as a result of their perceived race or ethnicity or those other categories that are protected and asked. The way that this bill is structured and the way that the data collection would be completed, to me, stops short of meeting that end. Because if you are asking an officer for a perception, they're going to guess, and they may very well be wrong. I think what I'm trying to do is be helpful and point towards a goal of collecting accurate data of who is stopped in Maine. And then maybe some judgments can be made from that as to whether or not there are certain groups or classifications of people who are stopped at a higher rate than others, or that higher rate than they should be. So I do understand what the sponsor of the bill had said about the perception. As I had testified earlier, you often don't know the reason, the race of the person or the ethnicity, oftentimes the gender or the age, before you stop them. So I don't see the correlation with once we do stop them and see them, guess what their race is, how that could somehow down the road translate to valuable information as to whether or not the officer stopped the person to begin with because of that ethnicity or race or gender or age.
Thank you, Major Scott. Just looking again at the members of the committee, are there any final questions? And I am not seeing any. Thank you for providing your testimony before the committee today. Next on our list is Jeff McCabe. I don't know if you were here earlier.
Is that accurate in saying? I believe I unmuted myself correctly.
Yes, and you'll have 3 minutes. I don't know if you were here earlier. You'll have 3 minutes, and then we'll ask you probably some follow-up questions.
I appreciate that, Chair Carney, Chair Harnett, distinguished members of the Judiciary Committee. My name is Jeff McCabe. I'm actually speaking to you today from Skowhegan, the wonderful district that Representative Poirier represents. I am speaking today on behalf of a coalition representing the vast majority of Maine law enforcement officers. Specifically, this coalition consists of the Maine Association of Police, the Maine State Troopers Association, the Maine State Law Enforcement Association, the Maine Service Employees Association, and the Fraternal Order of Police. We're here today to speak neither for nor against LD 132, but rather to provide our perspective and serve as a resource going forward. I would first like to say that we are not opposed to the concept of gathering the information that this bill seeks to collect. Indeed, we are collectively opposed to racial profiling in all its ugly forms. We want to be partners in the process leading up to improvements and necessary to change policing practices. We are not attempting to speculate nor speak to any implementation of any policy as a result of future analysis of this data that will be collected. Our concern with LD 132 rests in the manner of data collection. The data that will be collected, we believe, if this bill becomes law, we believe that mandating officers to apply subjective observations to determine the parameters of information called for in this bill is fraught with problems. In fact, it seems somehow we're looking to force officers to engage in the very practice that this bill hopes to eliminate. It seems to be setting up officers for more than an occasional failure as they engage in what could be said to be a guessing game. Information of an empirical nature is needed for any number of reasons during a traffic stop: for further identification as part of court proceedings, for administrative processes such as hearings by the Secretary of State, and the list goes on. The long and short of this is the legal system in all of its forms, in fact, mandates the gathering of certain information. So it seems somehow counterproductive and of a dubious value to have officers engaging in a guessing game that not only with the driver, but in some circumstances with the passengers. These stops often occur under dangerous weather conditions, low light conditions, and could result in people having to leave a vehicle to comply with this law. Given that the vast majority of traffic complaints are minor in nature, such as speeding or other traffic infractions, most often it is of no consequences who the passengers are beyond the driver. We know this bill is a product of earlier legislation. However, we would ask that the committee consider a process perhaps similar to LD 274 that looks at best practices for gathering the desired information. And again, we would welcome the opportunity to work with the interested parties, the committee, and the stakeholders to that end. Thank you, and I will attempt to answer any questions that you may have, and it might also be helpful for me to take the questions back to the other associations that are part of the stakeholder group. And as I said, I'm happy to take questions today. We're happy to be available during the work session, and we look forward to working with the committee on this issue and other issues as the session continues.
Thank you. And thank you for your offer to bring back to us information if you're unable to answer questions. We really appreciate you making the extra effort to get us accurate answers. So Representative Reckitt has a question. Go ahead, Representative Reckitt.
Hi, Mr. McCabe. Just a brief question. I've been trying to find out the variety of associations and unions that represent police. And I think you just named them all. But what I caught was the Maine Association of Police, State Troopers Association, the Maine Law Enforcement Association, SEIU, and I think there was one more. Can you tell me what the other one was?
Well, the other one I listed was probably the Fraternal Order of Police.
Right.
And there are possibly others as well. So this is just our coalition.
Okay. And
Yeah.
what's the name of your coalition?
We actually haven't named ourselves officially. It's really just sort of the associations coming together to talk about this issues and other pieces of legislation. And I think having served on the committee before, you probably realize sometimes you may hear from one of the associations, but not all of us collectively. And I think that overall, this is just a way for us to get together to serve as a conduit for folks, not only on this committee, but other committees as well. And I think you'll be seeing other folks from the coalition speaking on other bills. Today, it was just my turn to present this testimony that we came up together.
All right. Thank you very much.
Yeah, you're welcome. And I'll look, I think that I believe I'm accurate in saying this, that the Teamsters also represent law enforcement here in the state of Maine.
I think I've heard that. Yeah.
Yep. And there may be some others too, Representative.
Thank you.
Representative Poirier.
Thank you, Madam Chair. And hello, Jeff. It's very good to see somebody from my hometown. My question actually is based on you're telling me that the people that you're representing aren't opposed, of course, to the actual collecting of the data, but just in the manner of how it would be collected. And I certainly understand that as well. I brought that same position up earlier. And I'm wondering if there is another way that they're thinking that data could be collected to come to the same conclusion or end study that we're looking to get to get the information, or if they're just uncomfortable that they're going to be put in a situation that they might not want to give their true perception because of what it might look like, and maybe they wouldn't want to actually provide the information that actually is their perception.
Yeah, thank you for the question. One of the reasons why I said that, I may bring questions back to the committee is, I am not a sworn law enforcement officer. I've never worn a badge, but it's clear to me in talking with folks in law enforcement, and this is not a new issue. This is something that came up when the original bill that generated this bill came forward last session. And it was sort of that nature of the subjective observation. And so I think that Major Scott's point about having that information as part of a driver's license and part of the e-record is probably something that could warrant further conversation. That would then, create a situation where the traffic stop would occur. And then through the obtaining of that information would then be entered in the database through the entering of that driver's license. So I believe that answers your question. And I think so
I appreciate
that would be something. And one of the joys of this job is often when I testify, I get feedback afterwards from members who might be listening. Because of the nature of their job, they may not put themselves forward to testify. So I'll definitely bring back some more information, but that's the one that comes to my mind right now.
Wonderful, thank you.
Yeah, and I would say to Representative Babbage's point before, I just think of the women and men who are in law enforcement, and accuracy is a pretty important piece of that job. So, before when there was that discussion around the accuracy, I do believe, the importance of getting data. And we recognize that, but I also, just the level of accuracy is something I think by the nature of the job and the level of detail that's really important.
Thank you, Mr. McCabe. Senator Kime, would you like to ask your question?
Yes, thank you, Madam Chair. Mr. McCabe, I was wondering if you could provide your testimony to the committee in written form.
Absolutely. I'm trying to get into this new format of Zoom, so I figured if I gave it to the committee and then immediately uploaded it afterwards.
Perfect. Thank you.
Absolutely. Thank you.
Let's see, Representative Babbage, go ahead.
Oops, I just muted myself. Thank you, Madam Chair. Welcome, Representative McCabe. I just wanted to ask you to respond in the way that I was thinking about accuracy versus perception. If a person has a stop, goes about his business, the car goes on its way, the policeman returns to his cruiser, and he writes down Caucasian on the checklist because he thinks the person was probably white, but doesn't realize that the person identified as African American. The fact that he's African American in that case doesn't really matter, does it? It's the perception of the officer stopping a white person in his mind that we're trying to measure here as to are people being stopped based on some bias that they may or may not be aware of. So that's where I'm coming from with regard to what are we trying to measure. Do you see that? Do you understand?
Thank you for the clarifying point, Representative. And were you looking for an answer on that, or was that making a clarifying question?
You thought that was legitimate or not? That's all.
Yeah, I think that there's lots of questions around, the actual data. There's questions around sort of the accuracy of the data. So these are all definitely great questions, and I wouldn't sort of speculate. I understand sort of some of the discussion today as far as the different types of data, that could be collected depending on how, the data is actually collected. So absolutely. Thank you for that question, Representative.
Representative Moriarty? Steve, you're still on mute.
I still am. Thank you. Honorable former Representative McCabe, a question for you. I understand that the members of your organizations are trained in the importance of accurate observation. They may in fact be called to testify based upon observations made at the time of a stop or an apprehension or something of that nature. But this bill really is focused on one's immediate perceptions. And so I'm wondering if you can pursue with your members any potential pitfalls that you perceive with recording one's spontaneous perceptions, with the understanding that these have nothing to do with the validity of the stop, but rather simply identifying characteristics of the individual having been stopped.
Absolutely, Representative. We can definitely work on that and provide some information and some perspective as well.
Okay, thank you.
Are there any other questions on the part of members of the committee? I am not seeing any. Thank you so much, Mr. McCabe. It's nice to see you before the committee. And thank you for
the you all. Thank you. Appreciate what you do.
Our next, the next person who's here to address us today, speaking either for nor against, is Rebecca Graham from Maine Municipal Association.
Thank you, Senator Carney and Representative Harnett and distinguished members of the Judiciary Committee. My name is Rebecca Graham, and I am here to present testimony neither for nor against LD 132 on behalf of Maine Municipal's Legislative Policy Committee. Municipal officials support the data collection and sharing of the data that uncovers inequality in application of all government services. It's vital that that data is collected in real, reliable, consistent ways and is disaggregated, particularly when you're asking to spend local property tax dollars for that task. The UN Human Rights Commission provides an appropriate guideline published in 2018 specifically on how to do this in a human rights-based approach, and I'd be happy to send that to the committee. It leaves no group or individual behind, and it is self-identifying, which is vitally important for some of the categories that you're asking data collection to be established for, particularly as government agents. To truly uncover and understand inequalities, data must be disaggregated and recorded consistently, inclusive of multiple categories, particularly if future public policy is going to be introduced based upon that information, or justiciable, as I heard Attorney General Fry speak to. Relying on perception reinforces what we already know is current practice, and it can create some negative stereotypes for the use of that data. It also creates legally invisible groups, which in the US context disproportionately erases Indigenous and immigrant communities. And we need to be better than that when we're collecting this data. We have an opportunity with this bill to create a system using existing self-identifying sources to expand that collection in a meaningful way. And if there are pieces that are not adequate currently, we should be able to explore that within the existing system, particularly with ethnicity, gender, and race. Those should be self-identified categories, not assigned by a government agent at any point in time with an interaction. It'll also provide better data to help uncover the intersectionality of many of these categories. And it'll be far more accurate, as it has already been pointed out, and it'll be better reflecting those invisible groups. So municipal officials ask you to think about that carefully, to use another existing data collection method that doesn't use that subjective information, particularly in these sensitive areas. And with that, I'll be available for work session and able to bring back any other material that you may need on that.
Thank you very much, Ms. Graham. Are there questions on the part of the committee for Ms. Graham? Not seeing any, and thank you for providing the UN information that you referenced. I'd like to backtrack just a moment. Representative Hagan had his hand raised with a question for Jeff McCabe, and I did not see his hand raised. So, Mr. McCabe, are you available to answer a question? We may have to circle back with him in a moment. So Representative Hagan.
And I apologize. Thank you, Madam Chair. And I apologize. I got my hand up way too late. So if need be, I can just contact him, outside of this meeting. Thank you.
Okay. And if he returns to the meeting, he may have just stepped away for a moment, then we will renew the request. All right. And again, thank you, Ms. Graham. And the final person we have who signed up in advance to provide testimony, neither for nor against, is Sheriff Troy Morton. Sheriff Morton, would you like to proceed? And also welcome to the committee.
Thank you very much, Senator. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on Judiciary. My name is Troy Morton. I am the Sheriff of Penobscot County and also the President of the Maine Sheriff's Association. The Maine Sheriffs met to discuss this bill, and our position is neither for nor against LD 132. In March of 2020, Maine Attorney General Aaron Fry submitted his recommendations pertaining to collection and compilation of data on profiling in an effort to eliminate profiling in Maine. LD 132 was presented in response to those recommendations. Maine sheriffs were consulted for the filed report. Bias-based profiling is unacceptable, and we can and must collect data in a way that provides an accurate story of bias-based profiling. As leaders of county law enforcement, you have our commitment toward that end. Our hesitation to fully embrace LD 132 lies in the mechanics of the language, not in the goal of identifying and/or eliminating profiling. In November 2020, AG Fry noted, quote, "Bias-based profiling by law enforcement is a continuing matter of public concern. At the core of the concern is the trust of the members of our communities that they be treated fairly and appropriately in their interactions with law enforcement," end quote. AG Fry went on to say, quote, "The lack of data on such an important issue is not acceptable," end quote. The Maine sheriffs agree with a caveat that the data collection must be collected in a way that ensures its integrity. The language in this bill does not provide a clear path towards that end. One of the solutions offered by AG Fry was, quote, "implementation of a data collection and compilation program in Maine similar to California and Connecticut. As in other states, this would be a multi-year process. In addition, there must be safeguards in place to ensure the reliability and integrity of the data collected," end quote. If you follow this idea, it includes hiring a consultant with the experience in compiling racial profiling data. AG Fry identifies the overwhelming obstacle of decentralized and non-comprehensive data collection systems in Maine law enforcement agencies. To reach the stated goal of identifying bias-based profiling, we must immediately ascertain how to best collect the data in a way that would be accurate. LD 132 does not address the solution by requiring police officers to use their judgment. The probability of human error is undeniable. We do have a potential for a solution by looking to the state's Secretary of State's office. Adding race and other identifiable characteristics to Maine's licenses or state identification cards may be the pathway to capturing the accurate information. While it only begins to address bias-based profiling, it's a solution that offers data integrity. It also is an attainable outcome and has minimal financial impact that Maine sheriffs could support. While identifying bias-based profiling can and must be our goal, doing so with efficiency and sustainability is the only reasonable way to address this issue head-on. Maine sheriffs want to be part of the process as we work towards providing equitable and ethical future for all Maine citizens, regardless of race, age, gender, or lifestyles. The Maine Sheriff's Association deeply appreciates your consideration. I'd be happy to answer any questions that you may have, and I'll reduce my comments, and we're more than happy to attend the work sessions should you feel that's necessary.
Thank you very much, Sheriff Morton. At this point, I would turn to members of the committee and ask if anyone has a question they would like to ask of Sheriff Morton. I am not seeing any questions. All right, no questions. Let's see, and one final request if Mr. McCabe is no longer in our meeting as well. So Representative Hagan, if you could perhaps pursue some follow-up and then maybe bring that information and your question to us for the work session, that would be helpful.
I'll be glad to do that. Thank you very much.
Thank you. All right, and I will just ask in a final, is there anyone else who would like to testify neither for nor against LD 132? And I am not seeing any hands. Thank you, Sheriff Morton, again for your testimony, and many thanks to everybody who provided testimony this afternoon. That concludes our hearing on LD 132. And I believe that a motion to adjourn is in order, but I would like to check in with our committee clerk, Susan Panett, as she has appeared on the screen. Did you have a question or an item of business for us?
No,
Susan?
I did not. I just came on to say goodbye.
Thank you. Is there a motion to adjourn?
I move to adjourn.
Thank you, Representative Babbage. Thank you, everyone. We are adjourned until Tuesday morning when I believe we start at 9 with our confirmation hearings. Is that correct? Yes. Thank you, everyone. Have a nice couple of days until we see each other again.
Thanks very much. Take care.